Happy Friday night live, everybody. We've got a slightly rearranged setup. Oh, my Aura ring is on the charger. I feel so naked. I was like, why do I feel so naked? We can't go get it now. We're locked in because it is time for Friday Night Live. There is so much to talk about tonight. Hopefully, you guys enjoy the new microphone. We have a new microphone. I'm very excited about it. And not only do we have a new microphone, I have a new split screen setup, that we're going to explore together this evening. So tonight we are going to be covering a bunch of updates, and I reached out to the members and we're like, what do you guys want updates on? And that is one of the things we're going to be going through. So we are going to do a quick weekly roundup with all of our updates. Quick as a lie. I've lied. It's a lie. Quick as a lie. It's not going to be quick. We're going to do a roundup with all of the updates. Then we are going to look at the Amber Heard and Johnny Depp appeals. And then we are going to do a quick look at the new Erica Girardi lawsuit. And we're going to decide, is it clickbait or not? Because we're going to decide. You guys are saying I seem a little quiet. That might be, it is a new microphone, so you might have to adjust your sound. But yeah. So we will work with the mic sounds because it sounds cracking loud to me over here. And that's, I don't want it to be too loud on your end either because we don't want to peak, good sound matters. So we've got in our roundup, we are going to be talking about the great Utah cookie debate. It's going down in Utah over some cookies. We're going to talk about that. We're going to do some Rust updates. We're going to do some H3 updates, a quick Tati update. And then we're going to get into the Heard Depp Appeals. Then we're going to get into the Girardi lawsuit. So that is what we are doing. And with that, we should just get up and away. I see a lot of you asking about Murdaugh in here too. I will touch on it, but we just did the podcast episode. I forgot my earrings. That's what kind of day it is. You know what I didn't forget? The whiskey. We remembered the whiskey. So let me know where you're coming in from, what you're drinking. And we're just like away we go tonight. So everything will be timestamped below for you, replay crew, because we love you. And we're gonna put on earrings while we roll the intro. Cause WAP. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. I'm trying to not get my earrings stuck in my in-ears. You guys are like, you're not quiet, or you just sound a little bit softer. It is a different sounding mic. I'm going to get used to it. I'm going to be messing around with it because I'm getting a new soundboard. It happened. For all of you that follow me on Instagram, you know that it's been an adventure over the last week of dealing with my office. And then I had a family day. My family day got very interrupted by a gnarly headache. And for those of you that get headaches that have the next day headache hangover, that it is absolutely the worst. So the headache was real. The headache hangover was real. It's just been real over here. So you guys said the intro was so much louder than you. You know what? I gained this up during the intro so we would get the mic volume. So hopefully it wasn't too loud, but we will be, do not worry. We will be working on it behind the scenes. Lots and lots. Lots and lots, I promise. So I'm going to move around our screen setup in just a minute. And that, because now we have dual screens. Like I got one over there and I got one over here and I got y'all right there. And I'm still working on all the things, the members, and I got to deal with some of that setup fun. And it's been a lot of fun. So I've got like 3 things of water. My son did not screw this down very well. Travis was helping me get water before I was streaming because I was prepping so long that I was like, I prepped so long, we have to go. Loops Aguilar, I appreciate that V8 kills hangovers. The problem is I'm allergic to tomatoes. And it sucks. You know what I love? Caprese salad. And everything else that's made with tomato. Tomato is so good. But anyway, so I've got 3 things of water, a thing of whiskey, and some lip gloss. Tonight is a collab with Jen Girard. With Girard Cosmetics called Passion. I absolutely love this color. So that's what we're doing tonight. This is Passion. It is a collab color. I love it. So should we start with cookie? I feel like we should start with cookies. How many of you are following the great crumble cookie lawsuit debate? Put a 1 in the chat if you've been following this, because a number of you sent this to me on social and I was like, food lawsuits. I'm always going to say yes to food lawsuits. If you send me a food lawsuit, I am going to say yes. Don't worry, we're getting to Skittles next week because I've uncovered some other lawsuits and I am very excited about those. So let's get into crumble cookies and talk about this. Okay, I should put up a poll. Mingalina, if you don't mind putting up a poll, have you had crumble cookies, yes or no? I'm just curious how many have sampled the crumble for themselves. So yes, that's what we're going to do for a poll. And then at the end of this topic, we'll end the poll. But I want to see how many of you have had crumble cookies. Crumble cookies took over social media. They have a business model where they change over the flavors like every week. They have an app. They're big. They're warm. Emily, are you going to be controversial? Yes. They're not my favorite. I'm sorry. They're not my favorite. I'm still chasing this delivery cookie from when I was at UMass Amherst. And it might have just been because I was so hungry and so tired when we would order them in like the middle of the night. But nothing has ever been better than those hot delivery cookies at UMass in the middle of the night. They came with cold milk. I have no memory of what they were called. Any Minutemen in the chat that know these things, let me know. Love, love, love. Those are amazing. Then there is DD Reese cookies near UCLA. Also the best. You guys are talking about insomnia cookies. I've not had insomnia cookies. I saw insomnia cookies. When is insomnia cookies? Were they the ones near UMass? Do they just set up near colleges? Because brilliant. Because brilliant. It might have been. They delivered. They were delicious. It was the 90s. I have literally no recollections. You guys are like, no, it was insomnia. They were so good. And so with that, when we've tried the crumble cookies, I've been like, for me, they're just, there are other cookies I rather eat. Like there are other cookies I rather eat than crumble cookies. I'm just going to be perfectly honest. And I could go through a list of my favorites. If you're ever in the South Bay in Southern California, just go to Becker's Cookies. Do yourself a favor. They have the best cookies on the face of the planet. So good. Just do that. But that's not going to stop us from talking about these crumble cookie lawsuits, because there's now a hashtag. One of the cookie retailers being sued has gone like full Aldi on this bitch. They're just like, I'm going in. So it's time to do the roundup. We're halfway into a topic. Are we going to swoop in the middle of that? Yeah. It's time to round it up. Yeah, we're rounding it up. And our first weekly roundup is Cookiegate. The Utah cookie wars is happening. It's what's happening. So let me pull these up. So we're gonna have to change around our split screen. Ooh, it's our first time. No, this is not the article I wanted. If you paywall me, your article's not coming up. It's just not. We're just not doing it. So we are going to do that. All right. Emily, should you have done this before? Possibly. But I was so engaged with talking to y'all that I didn't. And now I have to go find where my other window went. There it is. All right. Let's see how this works with the new setup, y'all. The new. What? My cats are just going nuts. I'm like, it's Friday. They're just like, whatever. There is no professionalism happening with these cats right now. They're just like, we are here for it. We are here for it. 100. All right. Let's do that. Emily, are you still setting up? Yes. But I love this. I love this new setup so much. I can't even tell you. It's just been so nice. It's just been so nice. Look at how big the documents can be. Look at that. It's kind of glorious. It's kind of glorious. Let me know how it looks for you. I'm kind of digging it. It works great for me. It is just love. Okay, so here's what's going on. Utah's cookie war. Cult favorite Crumble sues 2 other cookie companies, including Dirty Dough. If I say Dirty Dom, I mean the cookie Dirty Dough. I don't mean Dirty Dom. I don't. But I covered all of the stuff going on with David Dobrik for so long that in my brain, I hear, I don't hear Dirty Dough, but Dirty Dough and another one. Well, we'll get to the other one. So the Great Utah Cookie Wars of 2022 sounds like an interesting movie of the week subject. It does. It absolutely does. It absolutely does. And I believe it is one of the owners of Dirty Dough that has taken to social media and is just like, ha, what we're going to do is talk about this all over social media and start a hashtag. But Crumble won over the kind of TikTokness. And I think that's why their cookies grew. Because if you look at Crumble cookies on YouTube, you have people doing crumbles of the week and people, it's become like a thing on social media. And it's Crumble specifically. Because if you're doing a thing of the week, you're doing the thing of the week. You're doing the trend that everybody else is doing. And that's how these crumbles have kind of taken over. And that's how I heard of them. I'd never heard of a crumble cookie until Peter Mon was like, this is what the 4 we got this week. And I was like, oh, what are those? And then there was one really near me. And then I was like, oh, what are those? And so now we are here. I'm going to move this mic just a little bit. So crumble cookies, not my favorite, but I'm very excited about this lawsuit because it has so much good in it that I'm very excited. There's 2 lawsuits. Crumble Cookies was founded in 2017 and gained national success through social media. The company alleges that 2 businesses are profiting off its successful trade dress. Here's a quick side note. Emily, what's trade dress? Trade dress. Trade dress is not just trademark. It's the look and feel of something. So it goes beyond just a logo. Trade dress can be looks and feels of packaging and things like that. This is a very, very laundered, pared down definition of trade dress. But trade dress can be like the look and feel of packaging and things like that. So the legal battle has been dubbed hashtag Utah Cookie Wars on social media. So if you want to see the shade that's going on social media between Dirty Dough and Crumble, though I think Crumble's largely stayed out of it, you can go enjoy that for yourself. Utah-based cookie giant Crumble Cookies is suing 2 smaller cookie companies. Let's see. In both cases, documents state, and I pulled all the documents, we'll look at them real quick. In both cases, documents state that each founder of the 2 companies had some sort of connection to Crumble before pursuing their own ventures. A family member of the founder of Dirty Dough was once a Crumble Cookie employee who left the company in 2019. The lawsuit actually says that they were a corporate level employee. And the Crave Cookie founder, I've called these DD and CC in all of my notes. The Crave Cookies founder was denied a chance to be a Crumble Cookies franchisor in 2019. They're like, we would love to franchise this. And they're like, no, you can't franchise this. And he's like, okay, then fuck you. I'll start my own. Fuck you. I'll do it myself. And so that's what's been happening. So although the lawsuits were filed in May, Dirty Dough based its response to this, Dirty Dough based in, they didn't list where it was based in. There's just a whole little thing missing there. I believe they're based in Arizona, though they have a location in Utah, responded to this suit in a press release to Utah Business on Monday. Quote, apparently this billion-dollar company Crumble is threatened by a startup with only a couple of locations to make a federal case out of rainbow sprinkles and rectangular boxes. So this is going to be an Aldi M&S type fight. And again, legally, Dirty Dough might be wrong. But in the view of the public, they might end up very, very far ahead. And this is what Crumble's lawyers have to consider. If really Crumble has hundreds of locations across the country. And if you go to their app, you can see them everywhere. They have hundreds of locations. Dirty Dough has a few. It seems that the other company also has a few. But Dirty Dough is going to build its brand off of being sued by Crumble. And so they are going to end up like Streisand affecting this whole thing, where Dirty Dough is going to be much more well known because of the cookie lawsuits. But, you know, after the Caterpillar cake lawsuit, we needed a good cookie lawsuit. So I'm here for it. In my travels, I will start looking for a Dirty Dough location so I can try them for myself. Because why not? But the sass is real, and they are taking out billboards. Yes, you heard that right. Billboards. Let your taste buds be the judge. Utah Cookie Wars. Cookies so good, we're being sued. Hashtag Utah Cookie Wars. Look, the marketing is brilliant. The chat's requesting the article be bigger. Okay, chat. You know. The chat is wise. Cookies so good, we're being sued. And then the picture of the cookie, y'all, is censored. Mm-hmm. You can't hurt our fillings. Utah Cookie Wars. This is not what I wanted to do. Our cookies don't crumble with competition. My money don't jiggle, jiggle. It folds. Anyway, our cookies don't crumble. They roll. So our cookies don't crumble with the competition. Hashtag Utah Cookie Wars. We don't just file lawsuits. We just have better cookies. We don't file lawsuits. We just have better cookies. So the thing is, Crumble has shaken the wrong hornet's nest. Even if they might have a legitimate claim, this lawsuit, even if they win in court, they could lose in the court of public opinion. And this is what a lot of lawyers just don't understand. We're pretty confused why a billion-dollar company is wanting to target two smaller startups out of Utah and Arizona. Crave Cookies owner Trent English told ABC4. As of now, Crumble has 330 locations nationwide, according to an insider essay by Comanzi Constable. Crave Cookies consists of 3 Utah locations, and Dirty Dough, founded in Arizona, has 4 locations in the Southwest, according to their company sites. In an exclusive statement to Insider, a spokesperson for Crumble accused Dirty Dough and Crave Cookies of using social media to spread misinformation and garner public sentiment. Oh, that's exactly what they did. They're just doing it better than you. They are exactly trying to use social media to garner public sentiment. I am not going to judge whether something is or is not misinformation. I am not putting myself in the position of fact-checking anyone. Whether or not they are spreading misinformation is really kind of irrelevant in this trademark suit. They are garnering public sentiment. Lawyers for Crumble, with all due respect, go look at what Aldi did to M&S during the Caterpillar Cake Wars of 2020 and 2021. Just go look. You're going to get Aldi'd. Aldi, I think, was clearly in the wrong trademark-wise, but they won the court of public opinion hard. They gave it to M&S hard, and that is going to happen to you. These smaller companies have nothing to lose by just going in, especially Dirty Dough. They already have a cheeky brand. So they're going to continue to be cheeky, and they're going to bring it to your backyard. Even if they're legally wrong, they could still win the court of public opinion. One of the defendant's brothers, who we also believe was involved in the defendant's business, was a former corporate employee of Crumble who had access to our recipes, schematics, processes, and other proprietary information. Okay. We have recently been told by a whistleblower with insider knowledge that the defendant misappropriated this information. That could be a very real problem, legally speaking. But it still might not win over the court of public opinion. It still might not. It still might not. Jenna Benna, thank you so much for this super chat. It is so great. Always wanting to show some support. Would you ever do a story with Peter Mon? I would love it. I mean, Peter, I'm sure I would absolutely collab with Peter Mon. We would have to find something to collab about, but I absolutely would. I think we talk. I consider Peter a friend. I'm lucky to do so, but I need to get to Peter's neck of the woods and maybe collab on a crumble cookie taste. Something. Draw Latina. Crumble cookies aren't anything unique. These are the same kindergarten cookies I made with my children to celebrate their birthdays at school 20 years ago. Can I sue for copyright theft? Probably not. That's the thing with recipes. Recipes are very hard to sue over. Let's go to the lawsuits because they have pictures. Are you just pulling this up because it has pictures? Yes. Let's look at Dirty Dough first. So Crumble is suing, let's just give a quick background. Crumble is suing Dirty Dough for trade dress infringement, which we briefly talked about, the look and feel of something, Utah Deceptive Trade Practices, Utah Unfair Competition Act, and unjust enrichment. They have not sued for, insider knowledge or anything like that yet. And then they're suing Crave Cookies for trademark infringement, unfair competition, false designation of origin, trade dress with the same, Utah Deceptive Trade Practices, Utah Unfair Competition Act, and unjust enrichment. A lot more has happened in the litigation with Crave Cookies than with the litigation with Dirty Dough, but Dirty Dough's name is more fun to say, so that one's going first. Is this how you decide things? Yes. I decide things by my own level of amusement. Tiffany said $33 for 12 cookies. They aren't even good. See, Emily, thank you for defining the Streisand effect. As I say things like, I believe we're all on the same page. Streisand effect, by hiding something, it publicizes it. Dude took a picture of Malibu Hills. Barbara Streisand got mad because her house was in it, blew up, and people came to look at her house. Exactly. And I think it was like an aerial from like the water, I think, with the actual Streisand case. But either way, Crumble LLC, Crumble IP LLC, and Crumble Franchising LLC, Crumble lawyers. I like the way you've set up your business structures. You have a separate IP LLC, very wise. You have a separate franchising LLC where you're most likely to get sued yourself, very wise. Good things. You need someone who understands social media on your team because otherwise you're going to get your ass handed to you in this case. Even if you win the trademark infringement, deeply nerdy shit in court, you need a social media person to consult with. Do that immediately. Just do that. This was filed in May. The reason we haven't heard anything about it is because the hashtag Utah Cookie Wars, started by the person being sued, is what popped this off into the realm of social media. But Crumble understands social media. Their lawyers might not, but they built their brand off of having a very Instagrammable, TikTokable brand. So you live by the sword, die by the sword, Crumble. Don't let Dirty Dough take you out. All right. Jurisdiction and venue. It seems that Dirty Dough does have a location in Utah, so that's going to make jurisdiction and venue in Utah appropriate. Crumble's business model. Crumble operates unique gourmet cookie business. Opened its first store in Logan, Utah in 2017. Ice. Has seen explosive growth since then. Yes. Somewhere after 2020, we all said we don't care anymore and we're just eating cookies. We don't care. And I love it. I love that people are like, I'm getting cookies. Good. Let's just, yes, even if they're not these. Crumble now has over 400 franchise stores operating in 44 states, including multiple locations in and around Phoenix, Arizona, the first of which opened January 30th, 2019 in Gilbert, Arizona. And I also think the targeting of college areas makes a lot of sense. To distinguish itself from competitors, Crumble sells its gourmet cookies together with unique trade dress and brand identity, has invested substantial time and resources to developing the trade dress brand identity, which has accrued substantial goodwill and brand recognition. This is the thing. If you have accrued substantial brand recognition, is anyone going to be confused by these competing brands? And that's the thing. That's the double-edged sword of trade dress. If you've done it so well that everybody's like, oh, that's a crumble cookie, then it's really hard to argue that someone else's brand is infringing on yours, because it's hard to say there's going to be enough similarities that it's confusing. So elements of trade dress, this is their vibe that they're sharing, the kind of the doodly type branding, the doodly type boxes, the doodly on the delivery truck. They're whimsical outline shaped drawings. They're doodles. I love a doodle, by the way. Doodling's baller. Doodling is a whole art form in and of itself. Love a doodle, but they're doodles. This is their unique packaging. This is their unique box. Nom, 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 nom is what I hear. Nom, 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 nom. Cookie boxes with no extra space that perfectly fit cookies lying side by side. Okay. The weekly rotating menu, which I think is also something that makes a lot of sense for Crumble, is that they have a rotating menu that keeps people coming back differently, or keeps people coming back for different cookies. So they talk about their trademarks that they own. They own the trademark in the box. Remember, fighting over Colin and Cuthbert was over the packaging. Over the packaging. And yes, this is like, they call it bubblegum pink, but it is really a Pepto pink in person. All right, let's get into the trade dress. These are crumble cookies. I think that looks like a Facebook page header. Great. Dirty Dough's Facebook page header. Oh my God, we both sell cookies, and we both have cookies in our Facebook headers. Crumble is verified. Dirty Dough is not. Dirty Dough has 43 reviews. Crumble has 3,289 reviews. Dirty Dough's going to get a lot more reviews because they're going to be much more known after this. Further, the following are side-by-side screenshots showing images of the party's respective cookie presentation and decor. That's very orange. Those cookies don't look the same. Do they look the same to you? Do those cookies look the same to you? By the way, of the crumble cookies I have had, this is one of the ones I have had. It's like a cinnamon bun cookie. The cream cheese frosting was actually pretty legit. It was one of the ones I liked the best. But yeah, isn't Cinnabon like, wait, isn't this just a ripoff Cinnabon? Look, we made Twix cookies. Look, it's a fruity cereal cookie. Look, it's a sprinkle cookie. You guys are like, these cookies do not look the same to me. Mm-hmm. Yes, over 16,000 of you now know who Dirty Dough is. Look, they both sell ice cream. In addition to copying Crumble's cookie presentation and decor, Dirty Dough has also copied Crumble's logo. Dirty Dough's logo includes a cookie with a bite out of it. Cookie with a bite. Cookie with a bite. Okay. Look, Dirty Dough uses boxes. Crumble uses boxes. Dirty Dough puts its cookies in boxes that are rectangular, and Crumble puts its cookies in boxes that are rectangular. What a point well taken for me by the CEO of Dirty Dough was, is Domino's suing like Papa John's because they serve a round pizza in a square box? Like, at some point it's food and it gets served in a container that makes sense, and containers for food are not the same. Those don't look the same. Ray's like, cookie with a bite, y'all ripped off Apple. Yep. Apple should just insert themselves into this lawsuit immediately. I'm teasing. They should not. They would not have grounds to. Oh my God, a single cookie in a single cookie box. Not to mention, this crumble cookie pink looks like literally every other bakery cookie box I've ever seen in my life. Don't all bakeries have pink boxes? Like every bakery. Every bakery. I just saw the point made by Celine. My local donut shop needs to sue them. They also use boxes, and everyone who lives here recognizes the box. Yes, and they're probably also kind of pink. Now I want donuts. Damn it. So yes, look, the box. And it says on the side, very big, Dirty Dough. Okay. Weekly rotating menu. I don't know if that's unique enough to trademark though. Voodoo Donuts uses a pink box. Oh, there's a Voodoo Donuts near me. Okay, donuts. Sorry. My brain just went to, I could go get donuts in the morning. I just got so distracted. Chat, I love you. Thank you. Someone's hungry always because I eat dinner after I stream. So my brain would go to food this way even if I wasn't hungry. Let's just be honest about what it is. So then they get into the trade dress infringement. Those are the pictures of the things they are saying are similar. I don't know if these things are going to be unique enough. I don't think the logos are that. I mean, the logos are just. The logos don't feel that similar to me. The layout of the packaging is the same. Okay, great. But I mean, this has a very different feel than the little chef guy that I think has a mustache. I don't even know. All right, do you want to look at the pictures from the other one? Should we look at the pictures from the other lawsuit? Great, let's do that. Let's look at Crave cookies versus Crumble. Slightly different. And the Crave cookies CEO, I wonder if the Crave cookies CEO is like, thank God the Dirty Dough CEO has just gone in on social media because I didn't really want to, but now like we're here. So it's great. Or is mortified and is like, please leave me alone. A lot more litigation has happened in the Crave suit. There's been an answer and an amended complaint, another answer, an motion to bifurcate discovery, like a whole bunch is happening in this lawsuit. But the beginning of it is essentially the same. Hey, we're Crumble, we're super unique. Mrs. Fields has to just be like, fuck all of you. Like, we've been doing this shit for ages. I mean, Insomnia Cookies had a lawsuit when I was looking at cookie lawsuits. Insomnia Cookies had a lawsuit back in like 2007 over kind of the same stuff. Anyway, maybe we'll look at that one too. Maybe we'll just go to all the cookie lawsuits. Here's Crumble's packaging and their Instagrammable, adorably stuff. It's all very cute. The Crumble cookie logo. Yay. We don't spell it with an E. It's very edgy. All right, where's the rest of the pictures of Crave? So they're angry again about the Crave's copycat marks. So they're saying that Crave is copying Crumble. The thing is, the fonts are more similar. Not exactly the same, but the fonts are more similar. They're both C's. The cookies are a little bit more similar. These logos are a little bit more similar. And they're saying that Crave is using a copycat logoing. This isn't about the boxes. This is about the logo. Yes, Pepperidge Farmer, absolutely like, y'all, there's some cookies. Girl Scout cookies came in a rectangular box too. Exactly. The Girl Scouts should get in on this. Girl Scouts. If anyone sells a mint cookie, go. Just go. Just go now. So I can understand a little bit more where Crumble is coming at from the similarities in the logoing. This is not over the trade dress of the boxes. I don't know how Crave serves their cookies. It's not here. The cookie presentation. Okay, I would try a waffle and syrup cookie. This also looks pretty good. S'mores also looks pretty good. So they're like, look, you also have a waffle cookie. We have a waffle cookie. The cookies look different. I actually think Crave's waffle cookie presentation is better. I like it. The key lime pie cookie, I think that looks very different. I don't know. Maybe that's just me. Look, a sugar cereal type of cookie. Great. Copycat add-ons. They both serve tumblers, y'all. I wonder where they source those. They're cute. We need some. We're going to go find out. Crumble's packaging. Crave's copycat packaging. Y'all, they sell cookies in boxes. What? Cookies in boxes. Holy shit. They sell single boxes with their logos on them, and they have a weekly rotating menu. So that is kind of and I said we were doing quick bits tonight. So if we need a deeper dive into all of this, the waffle cookie at Crumble's amazing. I'll have to try it. Key lime is super good too. Okay, y'all are going to make me try again. Can they call it copycat? Assumes facts, not in evidence. Well, it's to be fair, it's their complaint. So their complaint is their allegations and shade, and it's in the light most favorable to them. So that's why they are. The white balance on either my monitor or my face is killing me right now. Sorry, y'all. I moved my light, I changed things around, and now I look so pink. I am not this pink. I look very pink. I'm gonna have to change my lights. I look so pink. And Emily, are you bothered? Yes. But I'm going to change that. But before, we've got a few more topics we need to get through, and I need to get moving because we're like already 30 minutes in. I think we need a deeper dive into exactly what some of these lawsuits are because I'm fascinated. But we still have to get to all of the other updates. And to get to all of the other updates, we're going to need to stop this here. So Mary said designer here, fonts and brand marks are different enough for the copyright and trademark to be a non-issue. And all of this might be a non-issue, truly. All of this might be a non-issue. Miguelina, go ahead and end the poll. And while we do that, I do have a sponsor for today's stream. So we're going to do that and I will be right back. And I'm going to be looking at all of your chats while I do this and changing my lights. So a huge thank you to the stream sponsor. I've got to tell you, when they reached out and were like, we'd love to sponsor a stream, I was like, oh. Whenever someone reaches out where I use and enjoy the thing they are reaching out about, I get so unreasonably excited. I'm like, yes, please. And Two Dots is a game I have been playing for quite a while. I'm going to tell you about it. A huge thank you to today's sponsor, Two Dots. I'm not going to lie. I'm low-key at level 107 on Two Dots, like no big deal, but I absolutely love this game. Not because the main character is named Emily, but you know, we have main character energy over here, but because it is so easy to play, it's got a minimalist design, and it actually makes you think. I love a puzzler type of a game, and Two Dots has those puzzle elements that I love, plus little weekly challenges if you get stuck on a level. Like level 107, where I've been stuck for just a little bit. I've been using my boosters to help, but I'm still just a little stuck. What I really like about it is you can just get into this game when you have some downtime, when you need to reset. I've been traveling a lot. The music and the minimalist design are just a nice relaxer if I have a few minutes to sit and play before I board my plane. And I'm not surprised that they have over 115 million downloads globally because it's so much fun to play. You can collect, you know, the colors. You've got different challenges. There are different boosts for different levels, which makes it really fun. And the weekly scavenger hunt and treasure hunts are a nice little, you know, extra game inside the game. It's completely free to download and free to play, but if you use the link in my description with this video, it helps out the channel and it still takes you over to free to download on both iOS and Android. So go ahead and try out Two Dots for free. I think you will have as much fun as I have because, you know, we're law nerds over here. We like to use our brains, but it's really fun to do that in a relaxing way. So go to the link down below to download Two Dots today and let me know what you think. All right. Let's get back into the rest of today's show. Thank you all, and thank you again to Two Dots for sponsoring tonight's stream. We finished the poll with regard to have you tried crumble cookies? 75% of you are like, we don't know her, and 24% of you said yes. So I hope I'm not selling you cookies, cookies and mobile gaming this stream, but it might just happen. So support your local cookie shop in the way that you best see fit. That is the way to do it. So Liz N said, holy shit, DoorDash literally just brought crumble cookies to my neighbor. They are listening. Well, your neighbor probably ordered crumble cookies, Liz, and hopefully it's not because of me, but because they're good. I don't think you look pink. I think you look Lady Gaga. Thank you, Patrick. I appreciate that. Sprinkles Cupcakes needs to sue Crumbles copycat everything. New York State bar exam next week. Thanks for the support, EDB and Lawnards. Barney Cat, good luck with the bar exam. And Sprinkles did have their own litigation drama. We might just do a whole food show. I might just need to do that. We might just need to do an entire food show. And just, we need to do a tattoo copyright show as well. Oh Lord, these companies' trade dress is completely different. Are they pissed their ex-employees started their own companies? Yes, but you know what, Kiwi Girl? They didn't sue for, you know, inappropriately using trade secrets. There's no trade secret. They might add it, but there's no trade secret allegations here at all. So we'll see. Chips Ahoy logo is chocolate chip cookie with a bite out of it. See, Chip Ahoy should be mad. And isn't Chip Ahoy Keebler? I think it's Keebler. Um, Celeste Crawford said, do they need to have trademarked these before they could win? Oh, yes. To litigate it like this, you absolutely need to be trademarked. And Crumble has a bunch of trademarks. They attach them to all the lawsuits. Law and Lumber, somewhere in a hollowed out tree is a Keebler elf throwing two middle fingers at Crumble. Yes. Yes, there are. Emily, you need to try Hertz Donuts. They have some fun donuts. I will. I don't know about the name. Are they going to hurt me? I don't want to be hurt. I mean, most of the time. Question: what is the ultimate goal of Crumble's lawsuits against Dirty Dough? To make them change their box? And they're like, we don't like your box. And Dirty Dough's like, we're going to put that on a billboard too. Taylor RS said, why am I getting Mean Girl vibes? It's giving all the vibes. Don't tell her about pink sauce. Be very quiet. Betty the Cow, look, I tried actively not to go down a TikTok rabbit hole about pink sauce because I can't. And because I've just had so much else, but I've seen it. The last TikTok rabbit hole I went down was a viral video about pickup basketball, and I loved being down that rabbit hole. It was just so pure. I was like, oh, this is the fun side of the internet. Like, let's go down this rabbit hole of like pickup basketball and the viral video about pickup basketball, and like, y'all just organize yourself. It was comedy gold. I absolutely loved it. I loved everyone who partook in it. My brother used to go play pickup basketball. I don't know if he still does, but my brother would go play pickup basketball. Occasionally, professional basketball players from the Lakers would join them where we grew up because that's where we grew up. And they would just all self-organize. And I'm like, what is happening? That whole rabbit hole of TikTok was delightful. So there are definitely times I'm delighted by the internet. So food law show with Hogue. I will absolutely ask Hogue. Hogue is unfamiliar with the Murdoch case. Murdoch. I'm gonna switch between the two, and then I'm gonna piss everybody off. Not intentionally, but Hogue doesn't know Murdoch, so we're gonna need to do that. That there might need to be snacks for it because it's a lot. I can't see buying something I can make better myself. I also make them without the carcinogens. I mean, Tammy, I get it. I think the reason that I said your name wrong, I'm sorry. Yes, I think part of it is the fun of the rotating menu, is the fun of participating with something that's on social. The last time we picked up crumble cookies, there was nothing but teenagers in there getting cookies. And I can understand that. Just super fun. Pink is the traditional color for bakery boxes, right? Right. How unique is it? Corvallis, Oregon, college wine making pasta carbonara. I love that. That sounds delicious. I now need Emily saying nom 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 to be my text message sound. Nom nom nom. Cheers to you as well. And a huge shout out to friend of the channel, Amy Van Dyken. Hi. Cheers, friend. Because I know you're watching. It's good to see. All right, let us continue. We needed to get to Rust updates. Let's do Rust updates. So I don't have a ton of Rust updates because not all litigation zooms like some of the litigation that we follow. You know, most litigation slogs and then goes to trial, and then it feels like everything's happening at once. So when we talk about the Rust case, that's what we're talking about. Let me swoop. And for those of you not familiar with Rust, I'm going to give the briefest of brief backgrounds. I have lots and lots of content covering this case. On the movie set of Rust, Alec Baldwin shot a gun that was being used as a prop gun. And I hate saying prop gun because it makes it sound like it's like somehow not a real weapon, but shot a gun that was being used as a prop and killed the cinematographer on set, Helena Hutchins. After that, there has been a flurry of lawsuits. The police investigation is still ongoing. I know. Still ongoing. They're in the multitude of suits. The ones I have update on are 3 of them. And then we will circle back to the kind of tangential lawsuits in other coverage. The wrongful death lawsuit filed by Helena Hutchins' husband and then by a representative for her minor son, who's 10, is still having service going out. So on the docket, you're still seeing people being served with subpoenas. You have to get served with a lawsuit before you have to answer. And then a number of the answers are coming in. I have not seen an answer yet from Alec Baldwin. I have seen an answer from the armorer. Most of those answers are general denials. It's just like, deny, 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 deny. And that's exactly what an answer is. As to paragraph 1, denied. As to paragraph 2, denied. As to this allegation, denied. So general denials. I have not pulled those documents yet. Once I can, I will, because I haven't seen anybody else pulling them either. So we're just going to do it. So the request for jury trial was filed. If this goes to trial, it probably won't be until after the end of 2023, if not early 2024. That's where a lot of courts are. So the last that I saw from the investigation is that the FBI had the weapons and the DAs still hadn't made a charging decision, if there's any. I've broken down whether I think they can or cannot charge based on the information publicly available. So that we'll get there. We'll see. I'm waiting for some kind of a decision. The script supervisor case with maybe, you know what, let's do that one last. We'll go because that one actually has a new ruling in it and we're going to go over the ruling. The Sventnoy case, which was the gaffer case, has not had anything happen since 2021 at the end of the year. I don't even see if people have been served or responded. There's no answers filed. I have no idea what's going to happen with that case. So far, it is not moving along, but you need to serve people and get the process moving within 90 days. So we'll see. Amy Van Dyken as in Olympic swimmer. Yes, Olympic swimmer, most decorated Olympian for a long time. First Olympian to win, I believe, 4 gold medals in 1 Olympics, and friend of the channel. I'm just a big fan. So now I get to fangirl that we are now people. So the gaffer case is kind of at a standstill. No answers have been filed. It is unclear whether anyone's been served. There is a minute order from the script supervisor case. The script supervisor, Mamie Mitchell, is the one who hired Gloria Allred. I don't know if she's the lead attorney, but she's the one who gave the press conference when this case was filed. And with that, we are going to go through this ruling on the demur that was filed, just so we know where we stand on this. There's been the most litigation so far in this case. So we're going to look at this order right now. Let's see. That's not the right one here. You come over here. There we go. Emily, were you in the wrong thing? Yep. Was still in my crumble cookie notes. No, not helpful. We're getting used to having all of the screens. It's new. All right, let's see. Can we make this bigger? Yep, but not too much. All right, perfect. So this is from July 14th, 2022, so pretty recent. There was a hearing on the demur with motion to strike. Pursuant to the government code sections and the court rules, they had a court reporter. Counsels didn't object. Matters called for hearing. Matter proceeds by way of arguments as to the court's tentative. And what that means is that the court would have said, I'm inclined to do this, address it, and then let them just address that specifically. So the court orders as follows: motion demurs to the First Amendment complaint, moving parties. These are the moving parties, Brittany House Pictures and Anjul Ningam. And those are the only 2 moving parties. So this is a demur just as to these 2 defendants. How many defendants are there? A lot, including all of the producers, the tangential companies, et cetera, et cetera. Plaintiff Mamie Mitchell sued defendants and others based on injuries plaintiff alleges she sustained when defendant Baldwin discharged a loaded gun towards plaintiff. She was standing right by Helena Hutchins. Demurring defendants demur to plaintiff's first amended complaint. Plaintiff opposes the demur. A demur is called in other courts sometimes a motion to strike, but it is like, hey, you don't have standing for this thing. After a hearing on June 2nd, the court continued the hearing on the demur and ordered supplemental briefing as to whether under New Mexico law, the first and second causes of action in the first amended complaint state facts sufficient to constitute causes of action for assault and intentional infliction of emotional distress by these 2 parties only. So assault and IIED. When I broke down the Chris Rock, Will Smith slap, we talked about the difference between assault and battery. You don't have to be hurt, touched, or hurt for an assault. That's the battery part. So we talked about that a little bit there. That's why, even though she wasn't injured or struck, there is an assault civilly, not criminally charged here. And then the IIED. Demur. It's black letter law that a demur tests the legal sufficiency of the allegations in the complaint on the face of the complaint, like a motion to dismiss, on the complaint. In a ruling on a demur, the court must liberally construe allegations of the complaint, just like, again, liken it to a motion to dismiss. You have to look at everything in the light most favorable to the non-moving party, in this case, the plaintiff. Demurring defendant's demur. Demurring defendant's demur. Say that 15 times fast. Demurring defendant's demur to the first cause of action for assault and the second cause of action for IIED for a failure to state sufficient facts to constitute a cause of action and as uncertain, like we don't know what's happening. Specifically, demurring defendants assert that the first and second causes of actions are premised solely on Baldwin's conduct of pointing and discharging a loaded gun towards plaintiff without any allegation of conduct by the demurring defendants. What did we do? Nothing. We did nothing. So if we did nothing, then why are we in trouble? What did we do? Prove what we did. To satisfy the elements of either assault or IIED under New Mexico law, demurring defendants contend that plaintiff's allegations in the first amended complaint with respect to Baldwin failed to constitute assault or IIED. In opposition, plaintiff argues that the paragraphs of the complaint, these, allege facts showing Baldwin committed an unlawful act or menacing conduct that caused plaintiff to reasonably believe she was in danger of being killed, sufficient to constitute a cause of action for assault under New Mexico law. Plaintiff then alleges that in her other paragraphs, she first, of the first amended complaint, allege an agency, employment, or joint venture between Baldwin and the defendants, which imputes liability to them. Regarding her claim for IIED, plaintiff alleges that the first amended complaint alleges demurring defendants acted with reckless disregard of the probability that plaintiff would suffer emotional distress. So somehow they did something. I'm going to try to move this up a little bit. Sorry, y'all. We're going to keep messing with the setup forever. It's just... that's too high. All right. Not only did I get a new mic, I got a new mic arm. It's like, who is she anyway? We've got all new stuff. So, yeah, I might needed to move this up a little bit. So, where are we? Let's see. Safe handling of weapons. Here we are. Assault, first cause of action, assault. Under the New Mexico statute, assault consists of either A, an attempt to commit a battery upon a person, or B, an unlawful act, threat, or menacing conduct which causes another person to reasonably believe that he is in danger of receiving an immediate battery. So if someone points a gun at you and then fires it and is loaded and kills the person next to you, would you have been in fear? And then C, the use of insulting language. This is not that type of case. Deferring defendants rely on Baca versus Velez, and then they cite the case to argue that plaintiff first fails to allege facts sufficient to constitute the underlying cause. Hey, it's not because of us. It's because there's no cause of action at all. There's no cause of action at all. So plaintiff does not allege... plaintiff does not allege that plaintiff does not allege that she reasonably believed that she was in danger of receiving an immediate battery prior to the discharge of the weapon. So, did she know that on this set where there should never be a live round, that a weapon would even be fired? They said, finding no assault to have occurred, the summary judgment would have been proper. So they're trying to attack the entire cause of action, not just to them, but as to everyone. And that's a problem. Let's see. Plaintiff 79 of the First Amendment complaint states plaintiff is informed and believes and thereon alleges that defendant Baldwin assaulted her by intentionally acting without just cause when pointing and discharging a loaded gun towards her that was reasonably expected to result in injury to her and others. Plaintiffs 81 and 82 of the First Amendment complaint state as follows. At no time did plaintiff consent to having a loaded gun pointed and discharged towards her by defendant Baldwin while standing 4 feet away from him, including without limitation, because based on information and belief, there was no warning prior to having the gun pointed and discharged when plaintiff was standing 4 feet away, which is a little different than what Baldwin has said, but I go through Baldwin's interview elsewhere. Let's see. The script for the upcoming scene did not call for a discharge of a gun. No ear protectors were provided to plaintiff and other nearby crew members, and there was insufficient plexiglass inside the church at the time of discharge to ensure her safety. Well, because nothing was supposed to be discharged. Had plaintiff known that defendant would point and discharge a weapon in her direction, plaintiff would not have been inside the church and would have instead been outside of the church, viewing Baldwin's actions on an exterior screen with other crew members. Except on this day, there was no exterior screen. Why? Because they had all walked off set. That's why. Because they had all walked off. At the time defendant Baldwin pointed and discharged the gun, neither filming nor rehearsal had commenced, which also goes a little bit against what was said in Baldwin's interview that I broke down. Let's see. And then I lost my... at the time defendant Baldwin pointed and discharged, neither filming nor rehearsal had commenced. Plaintiff was standing less than 4 feet away. At the moment of discharge, plaintiff was standing adjacent to Hutchins, who was fatally shot and killed as a result of the discharge. Plaintiff was terrified and feared for her life. Immediately prior to... Paragraphs 56, 58 through 60 allege the following. Immediately prior to defendant Baldwin's deliberate but to plaintiff unexpected discharge of a loaded gun, the cast and crew, including without limitation defendant Baldwin, Hutchins, and Souza, were in very close proximity to one another. So that's unexpected. So if you're not in anticipation, is it an assault? This is really, really interesting because if it's not anticipated, is it really an assault? Excuse me. Several other crew members were also inside the church, including but not limited to a wardrobe person, camera operator, gaffer. At the time, plaintiff was less than 4 feet, was seated and had Hutchins to her left, and Souza behind Hutchins. Shortly before defendant Baldwin fired the gun, plaintiff was looking both at a picture of defendant Baldwin on her phone and at defendant Baldwin in front of her, including while he was moving the loaded gun within 4 feet of her to ensure continuity with the upcoming afternoon scenes. At this time, Hutchins was leaning down to line up the camera and setting up the scene. Souza was behind Hutchins. Suddenly, without warning, plaintiff heard and felt a shocking and deafening sound. And these are all in the complaint that we've gone over, which is interesting because Baldwin said there was back and forth between him and the director about the gun. Do you want to cock it, pull it back, all that stuff? But that is not what's in this lawsuit. She might not have heard it because she was focusing on her work, but they were all so close. I just can't imagine that if there was conversation about moving the weapon, she wouldn't have heard it. So it's a different account of things. So then they get to the second cause of action, the IIED, that this discharge and subsequent killing of Helena Hutchins caused intentional infliction of emotional distress. Like you're firing a weapon at someone, it's emotional distress, and goes through the facts again, which reiterate the complaint that we've already covered in depth. Plaintiff was severely injured without limitation, her health, strength, and activity, and sustained serious physical trauma and shock and injury to her nervous system and person, all of which injuries have caused and continue to cause plaintiff extreme mental, physical, and nervous pain. And then they go through more of what Baldwin did, that he was hired and worked with the producers, that they are part of this as well, which is why they're also being sued. Deferring defendants rely on State Farm Mutual Ambulance Insurance Co. versus Baldonado, I think, to advocate for a 4-step inquiry to establish demurring defendants' liability for Baldwin's intentional conduct. State Farm, however, addresses a specific issue of whether and under what circumstances a plaintiff in an uninsured motorist can recover for a passenger's intentional act. Very different case. They say here to establish demurring defendants' liability for IIED in accordance with Rael. Plaintiff must allege the demurring defendants, one, knew that Baldwin was going to point and fire a loaded weapon towards plaintiff. That is going to be very difficult to prove because there's no evidence that he knew that it was loaded. He was absolutely reckless with the weapon. You don't point a weapon at a person, loaded or not loaded. But to prove that he knew he was going to point and fire the weapon is going to be very, very, very difficult to prove. And two, provide him with either substantial assistance or encouragement to do so. They were just producing the movie. Well, let's get to the court's ruling before I give my 2 cents more. While plaintiff alleges that demurring defendants assisted Baldwin by supplying the loaded weapon, I mean, not directly. They weren't the one handing it to him. Plaintiff's allegations fail to establish that demurring defendants knew Baldwin would aim and fire a loaded weapon towards plaintiff. No one knew. Such that they would be jointly liable for his intentional conduct. Accordingly, the court sustains the demur as to the second cause of action, which means the second cause of action is getting heeded as to these 2 defendants only. Therefore, the court sustains demurring defendants' demur to the first and second causes of action with leave to amend. Oh, I didn't get the first one. Hold on. Where's the ruling on the first one? Okay, I'm going to have to go back up because I missed it. So the court is granting the demur on both causes of action, which is interesting. So we'll go back up. With leave to amend, orders plaintiff to file and serve amended complaint in accordance with the court's ruling in 20 days. You either have to allege facts that you knew and that he knew and that they knew that he knew, or you lose these defendants. Where is the first cause of action? Let's see. The court must have issued their ruling at the end of that section. Here we go. In short, plaintiff alleges that she witnessed Baldwin moving the loaded gun within approximately 4 feet of her, but did not experience any fear or apprehension until after he fired it. Because who on a movie set thinks that you're going to fire a loaded weapon at someone? No one. Because it shouldn't happen. After this case, if that comes up, somebody might be like, no, this actor had a weapon on set and pointed it, and I felt fear and apprehension because of what happened in the Rust case. But I think it'd be very hard for anyone in the Rust case to say that they were afraid until after, because who thinks that that's going to happen? It should never happen. He shouldn't have been pointing it. It shouldn't have been loaded. It shouldn't have been loaded with a live round. There's a lot of things that should never have happened in this case. Like so much failure, but that might not rise to the level of an assault. Plaintiff does not allege that Baldwin, after having fired the weapon, then engaged in any unlawful act, threat, or menacing conduct that caused plaintiff to reasonably believe that she was in danger of receiving an immediate battery. Consequently, the court finds the first cause of action fails to allege facts sufficient to constitute the underlying cause of action for assault against plaintiff by Baldwin. Without the underlying tort, the court does not reach the question of demurring defendant's liability. The court therefore sustains the demur to the first cause of action. So the court is sustaining the demur as to the first cause of action because they don't find that it exists. The court sustains the demur to the first and second causes with leave to amend. And we will see what the other defendants choose to do from here, because that first cause of action is going to be gone as to all of the defendants, because the court finds there's no assault. Because again, when you look at something like the Chris Rock, Will Smith slap, you can see Chris Rock, like, you can see kind of the apprehension, because once you see somebody like winding up to hit you in those seconds before it happens, you kind of know that's what's coming. Like, it's quick, but you know it's coming. With this, she clearly said it came out of nowhere. So if it came out of nowhere, there's no apprehension, and that's not going to give you an assault. So with that, I think these causes of action as to the script supervisor, the IIED, I think will stay for Baldwin and some of the others, but it seems like the court's inclined to get rid of the assault, and that means it's probably going to get heeded as to everyone. And that brings us to the end of our updates for the Rust case. Let's do YouTuber updates real quick. So YouTuber updates as to the H3 lawsuits and the Tati Westbrook lawsuits real fast. With regard to H3, there are multiple lawsuits going on. If you have not been following them, I'm sorry, I'm not going to give a very in-depth road so far because we are just doing quick updates. But a Hollywood producer, Ryan Kavanaugh, sued Ethan Klein and his company over things that were said on the H3H3 podcast, including that Ryan Kavanaugh's former business partner alleged that he was running a Ponzi scheme. If that sounds odd to you, yes. That is currently pending an anti-SLAPP motion hearing. There's been some additional briefing that we do need to catch up on, but we've gone over the other anti-SLAPP briefing. The anti-SLAPP is a motion against a lawsuit that is a strategic litigation against public participation in California. That's very commonly used in defamation cases. So with that being said, this is at its heart really a defamation case. Ethan Klein has already won an anti-SLAPP in California against Triller that is still pending attorney's fees. Last that I looked, and this is pending an anti-SLAPP motion that got put over to be heard on September 8th, 2022. So early September, we will see hopefully a ruling from this anti-SLAPP motion. If the anti-SLAPP motion is granted, then Kavanaugh's case is done. All of the cases are not done. There is still one pending in federal court, and nothing has happened since like March. Nothing. The court took something under submission to rule on. Nothing. DP Doughs make delicious cookies and delivers in my college town. So is it that? Yes, it is. Yes, it is that. It is exactly that. I don't know if DP Dough is still near UMass, but that is exactly what that is. Shannon, thank you. You've unlocked a core memory. Yes, that. Because insomnia, I was like, maybe? Yes, that. Yes, that. Yes, that. Yes, that. For those of you saying that we are blurry, I don't see it on my end, but check your settings on the stream and make sure your stream settings, because my broadcast is set to 1080, make sure your stream settings on your end are also there. And if not, try refreshing, because I am not seeing it on my end. And I know a lot of you are not seeing it. So CMS, I do believe that Nightbot is single. Nightbot is very sassy though. So, buyer beware on that one. Make sure that if you ask Nightbot that question directly, you ask it in all caps. Oh, it is hot in my office. I need to tell Dr. B, because it is so hot in here. Dr. B, why is it so hot? It's so hot. All right. He's not watching. If he was watching, I'd just be like, Dr. B, why is it so hot in the house right now? I'm so hot. All right. With that, we are going to get to the Tati updates, and then we are going to move on to Amber Heard, Johnny Depp, and Girardi, because there's so much going on. So I feel like we need another swoop. If you have not been following the Tati Westbrook lawsuits, it's so much. There's so many. But right now, we are just talking about Tati Westbrook, James Westbrook, her husband, and their former business partner, Clark Swanson. This is a lawsuit because of the defendant's greed. That's how this lawsuit started. This was the lawsuit that kicked it all off. This lawsuit was filed in October of 2021. It was, October 2020. It was filed in October 2020. So this lawsuit was filed in October 2020 and then kicked everything off with all of the Westbrook lawsuits and with me covering YouTubers. It was the first YouTube lawsuit that I really covered much. And it was filed in Los Angeles, California, chocked full of shade. It kicked off a very, very unexpected chain of events over here on this channel. But that is for another day. I digress. A lot of you were here for it. You know it. You know exactly what it was. So that case is filed in October 2020. That case gets yeeted out of California. Clark Swanson refiles it in Washington State with a number of other cases. Those cases subsequently get yeeted back to Nevada. In the meantime, the Westbrooks, through their companies, file lawsuits against Swanson in Nevada Business Court. Nevada has specialized business courts. A lot of people investigate there. It was great. It is great. I think it's a great way to set up their courts. So fantastic. So that case gets filed, and that case also full of tea. Full of tea. That case talks about Clark Swanson working with a YouTuber and giving them information that was company property. These, again, are the allegations in the lawsuit. Giving them company information, inside information that was then shared on YouTube. It was all of the things. And then that YouTuber had been in a lawsuit with Tati Westbrook, and that lawsuit settled, and that person turned on their source, and mess. Just mess. Those are the cases that are still ongoing, the Nevada cases. And there are two. I covered one in early June because Tati Westbrook has since sued the business partner. We covered that in June. Yeah, I don't remember when, but I think we covered that in early June when Tati Westbrook sued her business partner over the audio recording that the business partner took and the alleged extortion that came from that. Like, I've recorded this and I'm going to leak it. This is what they allege, and I'm going to leak it if you don't do what I want you to do. Big mess. So there are two lawsuits going on in Nevada. The new Tati Westbrook and James Westbrook as individuals versus Clark Swanson over the audio recording and the alleged extortion. And then the business partner lawsuits going on over the companies in Nevada. So what has happened then is that Swanson has filed a motion to dismiss on the extortion allegations lawsuit. That has been filed. There has been a oh, why aren't my notes up? Darn it, my notes aren't updated. There has also been a response to that. If you want to, I can absolutely go through the motion to dismiss. That's going to be heard on 8/3, so that's coming up soon. And that motion to dismiss is just in that new lawsuit that I just filed, or I just covered back in June. So that's somewhere on the channel. But where is my link? I meant to add my link to all of my Tati stuff, and I don't see it. But that was a really quick lawsuit. Let's just go look we're going to peek real quick at the motion to dismiss. Because I'm sure the response is also full of shade, because of course it will be. But let me pull up. There are so many folders of lawsuits. There's like folders and subfolders of lawsuits in this case. Let's see. Here's the complaint. So this is the one page. It's like 7 pages. The one claim complaint. This is a SALT-C case, and the local council there in Nevada. Exempt from arbitration, jurisdiction and venue, general allegations, November 2020. Swanson, this is after filing the October lawsuit. Swanson called a childhood friend of Westbrook. During the phone call, Swanson disparaged James Westbrook by telling the friend that James Westbrook had removed his mother from life support to steal his sister's inheritance, and that Tati should be worried for her safety. Where have you heard those allegations before, y'all? Where have you heard them before? During the same call, Swanson threatened that he had an embarrassing recording of Tati that he would release publicly to ruin her reputation and her career if she did not contact him immediately to settle the lawsuit then pending in California. This is a lawsuit because of the defendant's greed. You remember that lawsuit? That lawsuit had like a foreign prince of some sort lending money to somebody. It mentioned James Charles. It mentioned Sugar Bear Hair kind of tangentially. It mentioned Dramageddon, and it mentioned Carmageddon. It was that lawsuit was so much. At some point, we need to just revisit it. It was so much. Mr. Swanson told the friend to pass his threatening message along to Miss Westbrook, and that Miss Westbrook should take action to resolve the California lawsuit or he would ruin her. So that's kind of the underlying of this invasion of privacy lawsuit. And that is in the recording, declaratory relief under Nevada law, prayer for relief. So that's the extortion-y lawsuit. Lindsay is just like, we're going to trigger you. We're going to say nutraceuticals. We're going to say nutraceuticals a million times. KJ said, playing two dots while watching you, lol. Thank you. Well, I hope you're having fun. I hope you're having fun. Murderous conspiracies came up later, as did a motley crew of gossips building monuments to the gods of speculation. Like, this lawsuit had so much in it. I'm washing my hair. That's where Queen Levine came from. It's where Saltsy came from. So much of the inside jokes came from this lawsuit because it literally would not stop. It felt like every single week, if not multiple times a week, there were things coming out about that lawsuit. It was so freaking wild. Anyway, so this is going on with the business partner suit. The business partner then files his motion to dismiss. That is 25 pages long. Swanson loves a long filing. Not as much as Brown loved a long filing, but Swanson loves a long filing. Cav's lawyers love a long filing too. One of their filings is like 500 pages. Stop it. Stop it. Stop it. Stop it. Stop it. Nobody wants 500 pages. Any stacks in this lawsuit is internally stacked on top of itself. It is stacks and stacks of lawsuit. Oh my God, the 48 line page paper. I think it might have been 47. You guys, thank you. All of you are just like, oh, we remember. We remember. All right, motion to dismiss. We'll peek at this real quick. Introduction. This action, we can lift this up. Emily, are you going to play with your mic stand forever? Yes. It's not as easy. It's not as easy to move because this mic is, this is a different stand and this mic is so heavy. But we're going to adjust. We're going to keep messing with it anyway. Until we find the place where we're the most happy with it. All right. Mother bugger. This action arises out of a multiplicity of lawsuits stemming from California, Washington, and Nevada, all regarding a fractured business relationship with respect to several entities. Agreed. I agree. Look, we all agree on something. I agree. This is fractured relationships all the way around. The issue in the numerous different disputes goes well beyond the very narrow scope of this present action. I also agree. This particular action focuses on the sole issue of an alleged illegal recording that occurred on August 1st, 2017 at the home of defendant Swanson, located in Marina del Rey, California. Plaintiffs Tati and James Westbrook, collectively Westbrooks, filed this instant action regarding an alleged illegal recording under California Penal Code, asserting a private cause of action under this code for invasion of privacy and seeking an advisory opinion regarding the admissibility of the recording in future unspecified legal actions. So blocking it. We're going to block this later. Not only did the Westbrooks take nearly 5 years to file this complaint. Yeah, but the thing is, it didn't come up that the I don't know if they were aware of the recording. Like, nothing makes it clear to me that they were aware of this recording before Swanson filed it as an exhibit, or a transcript of it as an exhibit in the Washington case. And the Washington case was only filed like a year ago. Not only did the Westbrooks take nearly 5 years to file this instant complaint, they have folded in the argument that the 1-year statute of limitations was told under California civil procedure. The Westbrooks in their complaint never actually allege when they found out about the recording issue. That's a fair point. They allude to the date being sometime in November 2020, but as set forth below, they should have known about the recording's existence in August 2017. How? I'm interested on the factual dispute. That's interesting. As is set forth below, plaintiff's claims are barred by the statute of limitations. If that's true, it will be yeeted. Statement of facts. In 2017, Swanson and the Westbrook... I don't know why I can't say Westbrook this evening. It has nothing to do with the whiskey, I assure you. Apologies. Standard issue apologies to everyone's last name that I pronounce incorrectly, even when I know how to pronounce it correctly. Sometimes my mouth just doesn't cooperate with my brain. In 2017, Swanson and the Westbrooks were sole shareholders, officers, and directors of Halo Beauty Inc., a California corporation. There's multiple corporations, but okay. There's the Nevada corporation, and I don't know at what point this folded, but yes, in 2017, that was true. Declaration of Swanson attached as Exhibit A. On August 1st, 2017, a meeting of the shareholders, officers, and directors occurred at Swanson's home. This meeting was recorded with the full knowledge and consent of all the shareholders. That's not what the other shareholders say, though. As evidenced by the corporate minutes, which state this meeting was held at the residence of Swanson, lasted an hour and 40 minutes, and was documented by audio recording as agreed upon by the member attendees. A true and correct copy of the corporate minutes are attached as Exhibit B, but were they signed by everybody? Let's just go to Exhibit B. I have questions. Were they signed? And when were they signed? And were they actually signed? Let's see. Did the Swansons ever get the meeting minutes? Is what I want to know. Let's see. They're not signed. They're signed by Swanson. But did the Westbrooks ever get the meeting minutes? Like, how do you... Where's the email showing that you sent this to them? Like, first of all, this is a scan. I want to see the metadata. When was this document created? But also, when was this document sent to the Westbrooks? Just because you created it doesn't mean that they got it. Discussion included their detailed knowledge of the cosmetic industry and specifically the opportunity to disrupt brick and mortar establishments with a global e-commerce launch similar to indie brands Too Faced, It Cosmetic, Jeffree Star Cosmetic, among those brands noted by James and Tati Westbrook. 2017 was simpler times, friends. 2017 on YouTube was just simpler times. All right, let's go back up. I'm glad it's attached, though. It's attached to one of the other lawsuits, too. Let's see. We know the legal standard on the motion to dismiss, by the way, is kind of the same as the legal standard on a demur. You take it in the light most favorable to the non-moving plaintiff or the non-moving party. The Westbrooks claim they have no knowledge of the recording until a friend told them of its existence and supposed threats regarding the recording during November 2020, implying the date was the first time the Westbrooks knew such recording existed. The phrasing of the complaint has Swanson betting against himself to provide a date on which the Westbrooks discovered the recording. However, on or about September 24, 2020, excerpts of the recording were provided by letter to the Westbrooks attorney. Ooh, a true and correct copy of the September 24, 2020 letters attached as Exhibit C. Well, let's go see that. We love that. We love a letter between the attorneys. Exhibit A, Exhibit B, Exhibit C. I'm going to have to go through these. Clark Swanson has filed so many declarations. At some point, I've got to go through the declarations and see if they're all consistent because there's been so many across these different cases. Let's see. September 24th, 2020. This is, we're back to Mr. Fox. Hello, Douglas Fuchs. From Gibson Dunn. Settlement communication regarding Halo Beauty dispute. The settlement discussions. The settlement discussions that Swanson was really salty about. Reference back to my channel a year plus ago. Let's see. Dear Douglas. I'm writing at Clark's request. Well, yes, if you're writing on behalf of your client to make one last attempt to resolve this short of litigation. They requested quite a lot of money to resolve this, and I believe that the Westbrooks response was, fuck no. We're not paying you all that money and giving you our company. No. Never. Let's see. We love a good letter between the lawyers. I think the most significant obstacle we face is your client's refusal to acknowledge the deal they made with Clark on his patio in Marina del Rey. Contrary to what you are being told, there was no discussion of Klonopin on the patio. We're back to the Klonopin. There was no discussion about how Clark was not dedicating his time to the business, and there was no discussion about supposed erratic behavior. I know this because the conversation was recorded by Mr. Swanson with the Westbrooks' consent. Okay, well then they were made aware of the recording as of this date. When is this dated? It was at the top. Emily, go back to the top. That would be the shorter route. No, we're going around the horn. We're going around the horn. Damn it. It's not at the bottom. It's not at the bottom. September 24th, 2020. I should have remembered that, but I could not. Chevy says, my mom worked at Gibson, Dunn and Crutcher when I was growing up. Just a fun fact. It is a very large and very prestigious law firm. It is very fancy. They have lots of the fancy clients, all the things at Gibson, Dunn. I know this because the conversation was recorded by Mr. Swanson with the Westbrook's consent. So they knew at that time, or their lawyers were told at that time, which means they should have known. If this matter is going to be resolved short of litigation, they need to acknowledge the truth and their liability to Clark. We have had the recording transcribed. I have listened to the entire recording myself. Below are excerpts that prove Clark's complaint and directly contradict the Westbrook story. First, Tati and James explicitly promised to make Halo Beauty her exclusive brand in exchange for more equity. We're back to 2020. Tati Westbrook. So where I'm at is fine. If I'm 25% of this business, that's fine. I'll shill the vitamins. I'll put my name on it. But I'm going to fucking launch other products too, where I would feel more comfortable is if this was an actual brand where I feel like I was a part of it. Clark Swanson, I understand. Tati, instead of just a little, portion of it on the side because I want to build something gigantic. Swanson, okay, let's then agree on this. I hear what you're saying. I, first of all, really appreciate your candor. Tati Westbrook, I've lost sleep over this. I'm just like, Tati, what's taken out though? What are the ellipses? What are the ellipses? What are the ellipses? Tati, I have not even talked to you about this. I trust you. I trust you. I want to build a great brand. Now my name's on it. I really need smart, capable people that are going to help me expand and help all of this happen. And whether it's into a wet line or cosmetics or skincare, there's so much that we can tap into. I would prefer if it's under an umbrella than just do vitamins and then me go over here. So I think that's added value on the table as well. Ellipses. Tati Westbrook, I'm 100% good to shut that conversation down if we're all in agreement. Well, what happened up above? This is the thing. If we all feel good about it, I will be much happier than before, and I know you will be. I hope you'd feel like we're ready to build a brand. Swanson, yeah, all right. Tati, I'm not just a fucking bottle of vitamins, but the whole big thing. Oh, and not just a fucking bottle of vitamins, but the whole big thing. Swanson, yeah, if we're going to do it that way, I agree. James, I think he would. I think he will do it. Here's the counter argument to what you guys are saying. If you disagree with it, I'm with you. Halo Beauty Nutraceuticals, Halo Beauty Skincare, Halo Beauty Cosmetics. Halo Beauty is the umbrella. Tati, James Westbrook, but Nutraceuticals is the line. Clark, right. James Westbrook Skincare is the line, right. Cosmetics is the line, right. Yeah. Second, Miss Westbrook bragged about her ability to sell shit products. This is the stuff that I think he was trying to hold over her head that came out in all the other lawsuits. And we've talked about before. Tati said, but I think we all have value. I know I have to say I'm sitting here as the silent person in the room who hasn't really been involved in the discussion the two of you had. And then I don't know what was cut out. I want to know what my value is because I'm not happy. And what I bring to the table is enormous. Clark, I know it. Tati. And that's what everyone wants in a business right now is someone that can grab those millions of customers because I'm seeing it with my friends. I know what's around the corner. I know what's coming and it's all happening right now, even in the vitamin world. It's all happening. I know as far as our repeat customer, it doesn't matter. What I put my name on is going to work. It's going to sell, period. Because of the 7 years I put into building an audience. Clark, if you have a good product, Tati, doesn't even matter. I could have a shit product. Gummy bear hair blowing up. It's a biotin in a fancy bottle. I could go to them, boom, sell it. People would buy it because that's the way social media is. I have the kind of knowledge in social media that people can't turn to anywhere else. And I think that's fair, but this conversation goes on. We've covered, this is the exact excerpts from the other lawsuit that we've covered. But again, they always point to these arguments saying, see, it was an agreement. The thing about business though, is it was a discussion. This was a discussion before it was memorialized into a formal document. The person that memorialized it was Clark Swanson, and what he memorialized is not what he's suing over, and that's what makes me so crazy. Let's get back to the rest of this motion to dismiss instead of relitigating stuff from 2020 that is still ongoing in the other lawsuit, because all of that is about the other lawsuit. The other one. Let's see. But it is a fair point that the lawyers were told in September 2020. So pin the date there. Let's see. So they're arguing statute of limitations because it's beyond a year. Okay. And then the counter is that it's been told. Fine. The second claim should be dismissed as well. The Westbrook's second claim for relief is declaratory relief that seeks an order from the court finding that the recording may not be used in any civil proceedings. The problem is that the request is nothing short of a request for an advisory opinion and therefore should be denied. The reality is that if and when the recording is used in any civil litigation, the judge presiding over the civil action will be the one to decide on whether or not the recording will be allowed into evidence. And then they cite case law. So that's the motion to dismiss that is pending. We will see what happens and we will go through the response. The response is going to be like, there is law that says no. But we have to move on to these appeals or we are never going to finish things tonight. We just absolutely have to. So we're going to do that. But real quick, we're going to say hi to the super chats because 200 Watt Studio. More importantly, were there any muffins delivered to the meeting? 200 Watt Studio. This is a really valid point. If there were muffins, I think everyone loses. They have to be friends again and then move on. But I worry that there were no muffins. I worry. Allie Anderson said, facts. Amy Van Dyken is amazing. I agree with you. Got to meet her when she was the keynote at the 2015 AARC conference. I was a lowly grad student presenting my research. She signed my abstract. I would have asked her to sign my abstract too. The coolest. Love that she's a fellow law nerd. She is. I love it too. CMS said back to Alec Baldwin, Stranger Stories has the full video of his initial interrogation. The behavior of the two detectives was disgusting. I have not had a chance to watch it yet, but I absolutely will. Mika Plays Game says, all I knew about Tati was the James Tati Shane drama, and holy wow, it sure goes way deeper. Oh, Mika, there's a whole rabbit hole. There is a whole 2020, 2021 into 2022 rabbit hole because these lawsuits also had tentacles. There were so many, and they were fast and furious for a while. One of the lawsuits that settled has slowed the roll because that was the lawsuit that was popping off and dragging social media into it. These parties don't want to talk about this lawsuit, it seems. Tati rarely refers to it. It's not being litigated on social. It's just being litigated in court, which keeps the amount of litigation down. There's no allegations of hacking. There's just not a lot of wildness. There's court filings, there's information, but there's not so much wildness. Jinx said, my first super chat has to be for my girl, Emily. Thanks for representing Tennessee girls like the badass you are. Thank you. I mean, it is my adopted home state, so I appreciate that, and I will take it. Cheers. Cheers. The one and only, lost my hubby unexpectedly. Give me something to look forward to. Well, hopefully lawsuits aren't the thing to look forward to, but the law nerd community is absolutely here for you, the one and only. I know that there are many in this community that have lost unexpectedly, that have lost spouses. You are in very good company here to be surrounded by love and support, and you are always welcome to tune in here for a chat with your fellow law nerds. And I am so, so deeply sorry for your sudden and shocking loss. And, a cheers to you and to your hubby. I'm so sorry for your loss. We are here. Now I'm not going to go read the joking super chats because I can't. We'll get back to them. I promise. It was blurry closing and reopening the YouTube app. Fixed it. Thank you for fixing it. Thanks, YouTube. Lilith, we have talked about the Brandon Lee death and other content covering the Rust shooting. A tragic onset death. Absolutely. Regina said, felt sympathy for Alec till he said he doesn't feel guilty. Even if it's your fault, even if it isn't your fault, you should feel bad. I mean, he seemed to feel nothing. It was very strange. Tintin, hi Emily, thanks for the informative stream. You are so welcome. Sarah said, now my suggestible ass is baking cookies and watching. Well, I'm so glad. I'm sure you're not alone. ALB29, first time catching a live, fellow Nashvilleian. Love your channel. Thank you. Both DDs have ADHD and are amazing students, but it's hard. Thank you for what you do. It is hard. We have a whole house full of ADHD. A lot of people are wanting to know what flavor of whiskey you are drinking tonight. Salty watermelon. Salty watermelon is going to be the go-to for the rest of the summer. And then we'll get back to the salted caramel and the peanut butter cup and those things. But in the summer, watermelon is just what it is. So, let's see. Frankie said the owner of Crumble is 40 with a net worth of 13 million. Buddy, leave the little guys alone. Innovate and give yourself a new edge. That's what entrepreneurs do. We also have a Utah Biz Musk and Hustle. A Utah Biz Musk and Hustle code. Emily will save you 20%. Frankie, I love it, and I love the shout out. Go for it. The mods are like, no self promotion in the chat, but sometimes we love a cheeky little biz. And it's not a channel promotion. Maybe we weren't clear. I love it, Frankie. Musk and Hustle, you guys. Code Emily will save you 20%. There you go. Thank you for supporting the channel, and thank you for what you do. Yeah, it's fair to say. Here's the flip side of that. Miss Miggy said, "Wait, there's a peanut butter cup whiskey." Yes, Tennessee Legend makes the most incredible peanut butter cup whiskey. It has peanut butter notes with a chocolate aftertaste. It's perfection. What I was going to say about business and trademark. Here's the thing about trademark, though. Like, you lose it if you don't protect it. So you use it or you lose it is the thing. And you have to protect your trademark. I don't know if this is what they need to protect it from, but if you are seen to not protect your trademark, you can lose it, which happened. No, didn't happen, but was one of the arguments in the Rihanna Fenty trademark battles was, well, you haven't been shutting it down, so you can't stand on this one. So you have to protect your trademark. I just don't know if this might just not be the one, you know? So that's where we're at with that. All right. Now we have to go to all of the appeals. All of the appeals. All right, chat. Let's do it. Let's talk about Depp and Heard. Oh, I haven't told you to do the YouTube things yet, have I? Like, share the stream with a friend so they can find it. You know, we're here with our homies on a Friday night. Go ahead and do the likey, subscribey, YouTube things. Also, I forgot to mention this. A huge thank you. My brain has been elsewhere. Can you tell? A huge thank you to all of you who went and subscribed to QuickBits. We are over 100,000. We've been verified. We're like we're a real kid channel now. Not that channels aren't real before they're verified. It's just like, thank you, YouTube, because I have seen, and it does happen, that we will get people showing up in the comments, like a letter off of my name being like, hey, just text me at this. The scams are so annoying. They're so damn annoying. So having those channels verified really helps people not have my name and y'all thinking it's me. If on YouTube, if it's me, there is a check mark after my name and you will see it. So with that, we got to over 100 and I am so excited. So thank you. When we get a second play button, maybe I'll stream on that channel and unbox it over there. Maybe we should do that. Maybe we'll do that. We'll see. So, oh yeah, don't come scam the law nerds. It pisses me off so much. So the checkmark of clarity is the best thing. It really is. And almost every platform you will see a checkmark, not on Instagram, because Instagram's like, who the fuck do you think you are? And I'm like, I just don't want my people to get scammed in the DMs by accounts pretending to be me, please. But it's a problem. So anyway. Someone asked if I am sponsored by, I am not sponsored by any alcohol brands. I just drink what I like. And does your whiskey brand sponsor you? No, I drink what I like. They are local to Tennessee. I love supporting local businesses. I am always blown away when I'm like, oh, these things I love are all Tennessee local. We go to our local farmers markets. We support local farms and local creatives and local candle makers. I love that. I love the ability to do that. It's something I very much appreciate doing. So, and not appreciate doing, I appreciate the ability to do it. How close are you to 666K on this channel? Well, that's a great question. Let me go tell you. I'm going to tell you where we're at in this channel, and then we're going to swoop and get into the rest of the shit that we need to talk about tonight. But I can tell you that. Let's see. We are almost at 664. Like we are just a like scooch away from a Bing at 664. Let's see if we can pull up the live sub count. There was some sub count weirdness going on earlier in the week. I don't know what that was about. But YouTube occasionally goes through and is like, you don't need to be subbed anymore. Fuck you. And they just yeet things. It's so strange, but it is what it is. And my friend Renee Ritchie became the new YouTube liaison, the new YouTube creator liaison. I shared about that earlier in the week over on Twitter. It's so great. So yeah, we're getting close to 664, and that gets us a little bit closer to 663. So if you guys subscribe, you will start seeing this. Yeah, you'll start seeing it do that. So cheers. Someone subscribe, and we'll just, we'll roll over and then we'll move on. No check mark after your name on YouTube. Luann, you're probably on mobile. The check marks don't show up on mobile, which is a huge problem, but I'll show you what I mean real quick. Like when I'll show you on quick bits. So thank you. Yay, we binged. And then when we bing on the back end, I'll pull it up. We're going to go to quick bits real quick and I'll show you. We've got over 18,000 of us watching here. So when you go to quick bits, you will see, when you're not on mobile, you will see that there's this little check mark after the channel, but on mobile, it doesn't. Let's see. So it shows up right there at the end, and it does on this channel as well. So you'll see that there. So that's what that is. When I get to questions, I saw a few questions about Parkland. I will get into it next week. I will get into it next week more. I have not watched a ton of it. It is very, very difficult content for me to jump into. So when I talk about it, well, I will probably talk about it when it's done. And if it helps, I will talk about why they are doing a trial just on the penalty phase, because that will be easier for me to break down. I find school shootings to be tremendously triggering. So we are going to get into the appeals, and that is what we're going to talk about. But I do see those questions coming in, and I can explain like the procedure of stuff if that would be helpful. And same with as the Elizabeth Smart case gets a little bit further on. Gosh, I'm distracted by the Quick Bits channel. Okay, first of all, I'm going through Invisalign, so now there's like a little gap in my teeth that isn't normally there that will close up in future time. But why does YouTube just want to see my bottom teeth? Like YouTube picks these. I don't get to pick them. I get to pick them on Instagram. All YouTube wants is me like, stop it. This is not the face I want to pick, YouTube. Stop with this. YouTube. Pull it in. YouTube. Look. If you want creators that are moderately vain to use shorts, you have to make it easier for us to pick the thumbnail. Instagram makes it easy. TikTok makes it easy. You always have me looking kind of crazy, and I'm not here for it. Like, I get that it's YouTube and everybody wants YouTuber face. Whatever. I that's going to get clipped. Damn it. But I would like to be able to pick my thumbnail face, please. So it's not just me like, thanks, YouTube. I want to pick. That's what I should get to tell. Didn't realize they give you 3 stills and then you have to pick, or you can upload your own, which is way too much work for quick bits. It's just, they don't make it easy. There's tonight's thumbnail. So it's just frustrating. They don't make it simple. YouTube. But I like teeth and cringe face. It's a rule. Yeah, it's so cringy. We'll have to talk about my kid's rage later on about cringy things. He was so mad at me about something that was cringy the other day. And he was like, it's so cringy. I'm like, I'm in my mid-40s. Like, cringe is what I do. Like that's my job. I get to be cringy. I've earned it, damn it. All right. Appeals. We're doing Amber's first because it got filed first. That's just the way. That's the way that we're rolling. That's the way that we're rolling tonight. Let me just pull up this notice of appeal. Hey. Thanks, y'all. You're still doing the things. I appreciate all of you for subscribing that are here and are like, hey, we like to hear about law stuff and cursing and things. Great. So Wait a sec. What? Lizzie P. The Crave Cookie CEO is married to my cousin, and they are friends with the Dirty Dough CEO. The cookie thing is big in Utah, and everyone said Crumble copied Chip. Crumble is the least liked of these. Crave isn't confused for Crumble. I don't think any of them are confused by Crumble, and I think Crumble said that in their lawsuit when they said, we've earned this distinct branding. Well, if it's so distinct, nobody's confused. And who's Chip? We need Chip to get into it, and I'm not surprised that in Utah, cookies are serious business. I suppose if you are generally not drinking, then sugar becomes a substitute. Like a delicious cookie is just like, I get it. Cookies are a big deal. I love it. So thank you, Lizzie P, for that. And I love our 1 degree of separation. You can tell your cousin we were talking about them this evening. All right. I'm gonna swoop. Damn it. I'm gonna chat. I'll be back. I'm gonna come back and I'm gonna chat with y'all when I'm done with this, because now I'm getting all chatty and y'all are like, we are here to hear about these fucking appeals. Let's do it. Appeals. Yes, when somebody loses a lawsuit, they can appeal. This is generally predicated on the money they have to spend on their attorneys to appeal. Amber Heard has appealed first, so we're going to go through her notice of appeal first, and then we will go to Johnny Depp's. He has also appealed. You all are familiar with the case. A lot of you found me because of this case. Amber Heard has filed her notice of appeal. Johnny Depp has filed his notice of appeal. We're going to do a few basics before we get into the rest of the shit. Here's the basics. You can file an appeal if you lose. You can file a notice of appeal. After you file the notice of appeal, you have 3 months to file your appellate brief. So you let the appeals court know we're coming, and you make your reservation, and then you file your brief. Your brief is what lays out your legal arguments. So I see people already commenting on whether or not somebody's going to lose or somebody's not going to lose. Look, we don't know what their legal arguments are. We can surmise some of them, but we don't know what the legal arguments are. We don't know what their grounds are. We don't know if there was something wild that happened at a sidebar that's completely like, what? We just don't know. Appeals generally do not win. And there are times when appeals win that the result is, it doesn't matter though. You've won your appeal, but it doesn't matter and we're not giving you a new trial. The goal for Amber Heard is a new trial. So they have 3 months to appeal. We're going to go through Amber Heard's notice of appeal. We're going to go through the news reporting from the June 24th hearing because everybody wants to know how much money Amber Heard has to pay. And we're going to talk about that in a minute. And then we're going to go to Johnny Depp's notice of appeal. Okay? Okay, good. We're good. Let's do it. Let's just pull it up. Let's do this. Let's do it. When this was filed, I hasten to say a number of you were like, are we riding today? I was like, look, it's a 3-page notice of appeal. I am not going to throw shade at anyone who was like, let's just cover this today. But I am getting on a plane on Tuesday and I got to get the podcast done. And I just did not have time to get to it because I'm getting on a plane on Tuesday. Shit's going to pop off on Tuesday. Julie, I might actually pull up the Yahoo article that I was quoted in to talk about it. I might just do that. It might be on my list. I might just do that because I'm getting on a plane on Tuesday. And so I've been trying to get a little bit ahead so I don't get behind. Does that make sense? I think my ADHD friends are like, yeah, we know. But I am going to the Britney Spears hearing. Well, I'm going to line up and try to go to the Britney Spears hearing. There's no promises. We're going to try to go to the Britney Spears hearing on Wednesday. I don't think it'll be a problem. I don't think it's going to be hugely attended. It should be fine. So what's popping off on Tuesday? Everything. Everything is going to pop off on Tuesday. All the things. This is what I wanted to do. All right. Please take notice that defendant and counterclaim plaintiff Laura Amber Heard. Just kidding. Amber Laura Heard, pursuant to Rule 5.9 of the Rules of Supreme Court of Virginia, hereby gives notice of her appeal to the Virginia Court of Appeals from this court's June 24th final judgment. And that doesn't say and. From this court's June 24th final judgment order, the June 13th, 2020 order on the defendant and counterclaimant plaintiff Laura Amber Heard's post-trial motions, and from all additional orders and rulings by the trial court prior to the entry of final judgment. That's everything. Every ruling you made, every breath you take, we'll be watching you and appealing it. We're noticing appeal of fucking everything. Do I think they're going to appeal literally fucking everything? Probably not. Do I think they will at least appeal some of the things that they've lined out? Yes. I wonder what part of the post-trial motions they'll appeal. I wonder what part of the final judgment order and on what grounds. I want to see their legal theories and arguments because I didn't have a juror 15 imposter that was sus on my bingo card for this case. I mean, the court didn't either and yeeted it immediately, but still, it was not on my radar, if you will. Pursuant to rules 5.9b and 5.11b, Laura Amber Heard, Amber Laura Heard, see, I've said it once to be funny, and now it's stuck. Amber Laura Heard certifies that the transcripts of these proceedings have been or will be filed with the clerk of court within the time required by the rules. The transcripts are important because an appeal is completely based on the record. So the appeal is not based on new evidence. The appeal is based on the record from the case. So it is all going over the record. And that's it. That's the notice of appeal. Yes, her team put out a statement, and we're going to go look at that right now. So let me pull that. Hopefully it's in here. I think it's in here. I've got a couple articles to pull up and look at together. So we're going to do this one first. Is this the Yahoo article that quoted me? Yes. If you use me as an expert, I'm much more likely to use your article. That's just the way it is. Amber Heard files to appeal Johnny Depp's verdict. We believe the court made errors. Thanks, Taryn. Let's see. Amber Heard and Johnny Depp's courtroom showdown isn't over yet. No, we know. Oh, we know. Amber said she misunderstood the moving on assignment. She's the one who said she wanted to move on. Didn't Amber Heard officially file her appeal today? She filed the notice of appeal yesterday. I have not seen any notice that she has filed the appellate brief. So, but she will. She has 3 months. She should take some time to do that. Amber Heard and Johnny Depp's courtroom showdown isn't over just yet. On Thursday, the actress officially notified the court that she plans to appeal the verdict. Thank you for noting that it's a notice of appeal and not the full-ass appeal. We appreciate it. We believe the court made errors that prevented a just and fair verdict consistent with the First Amendment. A spokesperson for Heard tells Yahoo Entertainment, look, the First Amendment in this case is maybe not the argument you want to keep making. I have thoughts. We are therefore appealing the verdict. Defamation's not protected speech. While we realize today's filing will ignite the Twitter bonfires, look, this statement's more likely to ignite the Twitter bonfires than anything else that was said, because you keep banging on about the First Amendment and then trying to shut people down who are critical of your side. So pick one. If you like free speech, let it be. If you just want to wrap yourself in the blanket of the First Amendment and then tell everyone else they have to stop talking, that's not gonna work for me. It's not gonna work for me. Well, we realize today's filing will ignite the Twitter bonfires, and also, what about YouTube? What about TikTok? All of the media wants to talk about TikTok's impact on this trial, but no, they just want to talk about Twitter. That's okay, fine. Leave Twitter alone. It's the one and only time I'll ever say that, by the way. One and only time. There are steps we need to take to ensure both fairness and justice. That's completely fair. When you lose, you have the right to appeal. It's your right. Appeal, fine. Spend your money. Depp's team doesn't seem concerned the verdict will be overturned. Fair. The jury listened to extensive evidence presented during the 6-week trial and came to a clear and unanimous verdict that the defendant herself defamed Mr. Depp in multiple instances. Notice that they said herself. They're distinguishing the defamation from Depp and Heard, because Depp's defamation is through Adam Waldman. This defamation is from Amber Heard. So, the defendant herself defamed Mr. Depp in multiple instances. A spokesperson for Depp tells Yahoo, "We remain confident in our case and that this verdict will stand." Fair. Depp sued Heard for $50 million, claiming she defamed him in a 2018 op-ed. We know the facts. Last month, Judge Penny Oscarati told Heard's legal team the actress must pay the $8.35 million judgment with 6% interest per year for any appeal to formally move forward. Heard has not yet paid the sum, and her attorney, Elaine Bredehoff, previously said her client doesn't have the money. Heard has only paid the $500 to start the process. It's unclear how the rest will be paid. On Thursday, Heard's team filed a 3-page notice of appeal in Virginia court. The grounds for the appeal are not laid out in the document. Last week, Judge A ruled against Heard's motion for mistrial, spectacularly, I might add. The actress's team claimed that there was an apparent case of mistaken identity with Juror 15, but the judge declared there's no evidence of fraud or wrongdoing. Legal experts don't believe Heard will win her appeal. Andres Munoz, litigation partner at Romano Law, tells Yahoo this appeal is a Hail Mary attempt to get a verdict, or to get the verdict overturned. I mean, all appeals. And it's incredibly unlikely to be successful. I mean, some appeals have solid grounds, I guess. This one doesn't. To win the appeal, Heard will have to establish to the appellate court that the verdict was plainly wrong or was without evidence to support it, an extremely high legal standard to meet. And an added challenge for Heard is that the appellate court must review the evidence in its light most favorable to the plaintiff, Depp, thereby giving Depp the benefit of the doubt on all evidentiary matters, unless there is a ruling that the court made that's clearly wrong. And so if the court made a ruling that's clearly wrong, we'll get there. Legal analyst Emily D. Baker. Do we know her? Yes. Also notes appeals are generally unsuccessful. I did say that. It will be interesting to see what rulings or legal theories Heard's team puts forth. So far, they have been wholly unsuccessful in their post-trial motions. Interestingly, Amber Heard's team keeps arguing that the jury verdict is inconsistent with the First Amendment. However, defamation isn't protected speech, and the jury decisively found Heard's statements defamatory. Baker notes it's also still possible that Depp will file notice of appeal. As he lost one count of defamation, he must do so before Sunday, July 24th. This article is from July 21st at 1:30 p.m. I said he was going to appeal. Well, no. I said it was still possible. I should have said it was likely. Maybe I should have said it was likely. Duh. So, with that, Yahoo is reporting, and I've seen others report as well, that Judge Oscarati already said that she has to pay the $8.3 million judgment with 6% interest to formally appeal. Why not 10? Because she's awarded 2. So, D Stank, did you cherry pick this article for the name drop? Absolutely, I did. Yes, I did. Yep, sure did. Also, because it had the bit about what Judge Ascarati said on the 24th, we're going to get to one other article that talked about it. I think that that's a really important part because the statute says that the judge can set a different bond amount. So the judge could set the bond amount different from 8.35 million, but didn't. The judge made it clear at the June 24th hearing that Amber Heard is going to have to put up a bond in the amount of 8.35 million with the 6% interest. There's a lot of reasons that can happen. Elaine Bredehoff, I can't wait to get the transcripts for that. Andrea Burkhart has ordered them with community support. I can't wait to see people go through them. I can't wait to go through them myself. I want to know what happened on June 24th. But all reports from those in the courtroom said that on the 24th, Elaine asked to not pay the full amount in bond, and the court was like, "No, ma'am. Put your money where your appeal is. Do it now." Sorry, that was. Oh, now we banged. Look at us. There we go. We love it when we bang and the lights flash. The fact that I got that all to work is still one of my proudest moments. I'm like, I made things work. We should celebrate as we keep going on. We should just, because it banged.
Oh,
It binged! Move your head! Ah! Yes, for all of you in the chat that are like, Judge A's not playing, Judge A is not playing. And I still see some questions in the chat. Wait, did she put up the 8.5 or the 500? She has currently put up $500 based on reports. That's all. She has not yet put up the rest of the appeal bond. She has to put up the rest of the appeal bond. I don't know if she has to do that. This is the timing I'm confused on. I don't know if she needs to do that before the date for the notice of appeal runs out, which would be this weekend, or if she has to do that within the 3-month window. We've gone into flight attendant mode. Within the 3-month window when she files the official brief. Like you cannot you can file your notice and preserve your right. You have 3 months to file your brief, and then you must file your bond when you file your brief. So I'm just not sure on the timing of that. All right. With that, there's one other, where's the other article about what Judge A said? That's what I'm looking for. I thought I had pulled a few. No, where'd it go? I'm not sure where it went. I don't think it's this one. Anyway, there were other reports I had found. When I find them, I'll share them on the Twitters. But there were other reports that confirmed what Yahoo said from people in court. I wonder if it's over on Chanley Painter's Twitter. I will go look. I'm just looking and seeing if it's in this. Here, it's also noted in People, but I think they're all citing to the same sources, but nobody is talking about which source. I really want to see the transcript on exactly what was said, but we don't have that, and I didn't go to the hearing. So when the judge made the verdict official late last month on the 24th, she ruled that the damages will come with a 6% annual interest and noted that if Heard were to appeal, she would have to post a bond for the full amount of damages she owes. So that's what was said. If it needs to be done by the 24th, then it needs to be done. I mean, well, if the date falls on, is the 24th Sunday? If the date falls on the 24th, I think that's Sunday. What's today? Is today the 22nd? Yeah, then it would probably be Monday. So we'll see. Judge Hayes, a Marine. Marines do not play. Fair. Where is she getting it? I don't know. I don't know where the money's coming from. Oh, it's a lot of money to post on a bond. But if you're going with these parties are not done fighting with each other, wouldn't it be better to post it as a bond and not give it to the other party? And if she does post it as a bond and loses, at least then it will go to Depp when she's done. And that's something. So at least the money will be sitting in kind of escrow. So he might not have to track it down as much, and he doesn't have to pay her the $2 million. He can post it as a bond and be like, fine, fuck it. We're all appealing. Fuck it. Hold the money. And for him, I'm sure he's not very stressed about where the $2 million is coming from. He's like, yeah. I'll get it back when we're done. So you guys are reminding me Sunday's the 24th. So Monday then would be the next court date. So let's see. Let's talk about Depp filing an appeal. Not surprised. I think when we're looking at the theories of how we got to these jury verdicts, the verdict on the Waldman claim is a bit more baffling. We're going to go through the objections that Depp's team made because it's likely the grounds that they're going to use when they appeal. So we'll do that. Let's see. So we'll go through the notice of appeal first, and then we'll go to the other stuff second. Thank you, guys. I still see you subscribing. The ticker's still ticking here in the background. I can still see it. It's still doing things. It's always fun to watch it do things. So thank you. I'm amused when I get to watch it do the things. So thank you. All right, let's pull this up from Brown Rudnick. I appreciate that they broke down what they paid. Like, thank you. Thank you. Let's see. I saw a question that I wanted to keep. Okay, there we go. Via hand delivery, Dear Mr. Frey, please find and close the filing in the above referenced matter the following: a notice of appeal to the Virginia Court of Appeals, a check for the $32 filing fee, and an appeal bond for costs, together with a $500 check for the appeal bond. So that's the initial appeal bond. Pursuant to Rule 5A6, a copy of this notice of appeal and the applicable fee has been filed with the Virginia Court of Appeals. Notice of appeal. Plaintiff and counterclaim defendant John C. Depp by counsel hereby appeals to the Court of Appeals in Virginia from all adverse rulings and from the final judgment order in this circuit court entered on June 24th, 2022. Pursuant to the rules, transcripts of the incidents of this case have been previously filed. Additional transcripts may be filed. And we saw all of those in the record, all the notice of filings. That's all the lawyers. This is the certificate of who everybody is. These are all their lawyers. Appeal bond for costs. Thank you for filing it. Having appealed from a judgment the court rendered on June 24th, as principal having deposited cash in the amount of $500 as a bond with surety pursuant to Virginia Code 1-205 with the court of the clerk, has bound himself and his heirs, successors, personal representatives to appellee Amber Laura Heard in the sum of $500 to satisfy all damages, costs, fees that may be awarded. And that's it. So let's talk about what I think will be some of the things that will be appealed, because we saw it in the final judgment order. And that again, this is why I didn't do a separate stream to just cover the appeal, because it literally is, we're going to do things. We're going to do things. These are probably the things they're going to do, because these are the objections to the final order. There could be additional things, but I think this is a good place to start with the things that they're intending to do. All reasons stated in oral and written arguments, indemns, demurs, pleas and bars, motions for summary judgment, motions to strike. All the arguments we made before. All the reasons stated in oral and written arguments in Mr. Depp's motions, jury instructions, and motions in limine. The motions in limine that should be getting unsealed, so we'll actually get to see more of them. The court's legal finding that Ms. Heard could prove actual malice by relying on the mens rea, and I had a typo on this that some of you might have caught on Twitter. Mens rea, iPhone. There's no apostrophe on the S. We're not talking about men's. We're not talking about like the mans. We're talking about mens rea. Oh Lord. The court legal finding, but I just watched Real Housewives Ultimate Girls Trip season 2, which I loved. And when people were talking about mens rea, I was like, okay, don't make jokes about manginas. Don't make jokes about manginas. And then I was just the meme. I could just see the meme. I'm sorry I called your husband a mangina. I couldn't help myself. Anyway, we're moving on. We talk reality TV here. If you didn't watch Real Housewives Ultimate Girls Trip, you are so confused about what I'm talking about, but it was a hoot. I really enjoyed it. I liked season 2 quite a lot. I thought it was fun. I thought it was a lot of fun. All right, we're moving on. So the court's finding that Ms. Heard could prove actual malice by relying on the mens rea of either Mr. Depp or Mr. Waldman by permitting Heard to argue the same to the jury in closing. I think it's a really interesting argument. And of the legal arguments we've seen so far, this is the one I'm most interested to see them brief, because it is interesting. It should have to be, in my mind, I could be very wrong, but in my mind, this is, okay, I'm going to back it up because I think I'm going to start in the middle. We're going to back that thing up. We're big fan. We're backing that thing up. For Depp to be liable for defamation for statements made by Adam Waldman, the lawyer, Adam Waldman had to be an agent. He had to take on essentially being Depp. For all intents and purposes, it's like, I'm standing into your shoes and I'm making this statement as your agent, so much as your agent that you can be held responsible for the things I say as if they are the things that you say. So I really want to see the case law in Virginia about whose state of mind to go to the knowing falsity it is. And is it Waldman's knowing falsity or is it Depp's knowing falsity? Who knows the statements are false? And so when we're talking about the state of mind, and that's what mens rea, the state of mind, when we're talking about the state of mind for the thing, In this case, the thing is the malice. Who has to have the malice? Depp or Waldman? And I really, really would like to see it break down, because if Waldman's statements are taken as Depp's, then the state of mind, in my mind, should be Depp's state of mind. And that Heard would have to prove that Depp knew that Waldman's statements were false when they were made and had a knowing disregard for the truth. That would have been a very interesting argument for them to have to make when it comes to the spilled a little wine arguments. Depp wasn't there. How are you going to prove that he knew they were true or knew that they were false? So I think it's an interesting argument. I don't know if it will fly to get a verdict overturned, but I am looking forward to seeing the briefing on it, because of all the legal arguments. I'm like, love living peach dream question, but wasn't Waldman's statement true? The jury found that it was defamatory, which means they found that it at least wasn't true enough to be defamatory. And when it comes to the spilling a little wine statement that they were trying to hoax the police, I think there was enough evidence to show that there wasn't a second call to the police. That was never put in. Yes, I know the internet knows that there's more, but the jury doesn't. And we have to go on what the jury knows. What the jury knows is the two different sets of officers showed up and didn't see the place trashed, didn't see wine spilt, didn't make a report. So I think it's fair to talk about Waldman's statements in count 2 not being accurate. They weren't accurate, and the jury found that they weren't accurate. So I think it's fair, but you have to prove that someone knew that they weren't accurate. Who has to know? Evo says, but there was a second call. Rocky made it. The jury never heard that. The jury never heard about a second call, ever. So the jury doesn't know that there's a second call. So in this trial, there is not a second call. The internet knows. The jury does not know. So with that, that's the argument. When we come to the appeal that I'm very interested to see. Kimberly asked, will there be different jurors? No, there will not be any jurors. Because it's the appellate court, there will be judges. Sometimes one, sometimes a panel. So, they believe that statement 1 of the 3 was false. They believed that the second statement. So there were 3 that were sued over, and it was number 2 that they found to be defamatory. And in their finding of defamatory, they have to necessarily find that it was made with a willful disregard to the truth. So they're finding that the statement was defamatory, meaning that it had to have a willful disregard for the truth. And I can see how they can get there based on the evidence. All right, let's continue on. That's the argument I'm the most interested in. The court's failure to exclude inadmissible hearsay statements. So they're saying the court should have kept more out. The court's refusal to sustain Mr. Depp's objection to improper argument made by Ms. Heard's counsel during closing argument and motion for curative instruction. Ms. Heard's improper argument at closing told jurors that finding in favor of Mr. Depp would send a message to, quote, every victim of domestic abuse everywhere, which is an improper invitation of the jurors to decide the case on larger societal issues and to place themselves in the shoes of Ms. Heard when reaching their verdict instead of basing their verdict on the evidence presented. I think that's waived because they didn't object at the time. The jury's finding of defamation by Mr. Depp as to the statement made by Adam Waldman that, quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine and roughed the place up, got their stories straight under the direction of a lawyer and a publicist, and then placed a second 911 call, as contrary to the law and unsupported by the facts. We'll see. The jury's award of $2 million in favor of Heard against Depp in connection with the jury's finding of defamation was excessive. All other objections made. So I think that's what we'll see. I think that's what we'll see in the appeal. Let me see if there was anything else I was going to pull up on this before we get to one last thing and then questions. But really, that's it. We'll see these appeals filed. We'll see the briefs filed. We'll cover the briefs. And when we cover the briefs, we'll go through their arguments. I'll probably read some case law as we're going through the briefs. I want to see what the lawyers argue, but I will probably look. I will probably look at some of the case law underlying it when we get into these appeals, because we're going to be talking about them a lot. So the process of appeal is that this is done on the record. It goes to the appellate court. In Virginia, I think they go with one judge first, and then they can go en banc, but we'll see what they do. Am I an expert in appellate? No. Is it 90% of what you do in law school? Yes. Trial court is where I love. Trial court is the level that I love. It's the stories, it's the strategy, it's the drama, it's the juries, it's the all of it. It's the unexpected, it's the thinking on your feet. The appellate court is, we are reading the transcripts, and we are looking at the law, and my learned friend is deciding. Okay, that's not nearly as entertaining as, a lawyer standing in court saying, aren't you here for your 15 minutes of fame? And the witness being like, the same can be said about you, bitch. What? Don't come for me. So that. Pink Monster. Why wasn't the second call allowed in court? I have no idea why it didn't come up. We didn't see a lot of those motions in limine. When we see the motions in limine, maybe we'll get to see. So that's what it is. All right. You guys, we're going to look at this new Erica Girardi thing real quick. Betty said, weren't both sets of officers deposed? Yes, both sets of officers were deposed. The first weren't wearing body cameras, but the second group of officers wore body cameras. Surely the jury heard depots of both groups of officers. Betty, yes, the jury heard the depositions of both groups of officers. But the second group of officers said that they were still responding, they believed, to the original call. They didn't say that there was a second person that picked up the phone and called back the police. So, and that happens. And that's what the dispatch logs indicated as well. So that's why they ended up both being out there. The thing is, there's not evidence that they got their story straight, that they spilled wine. The second group that came out the second group that came out had the body cams. They didn't find the place trashed. They didn't find wine spilt and things like that. So it's just, let's see. Is there a general idea that appellate appeals don't go through? To do so would be find great fault with the presiding judge, wouldn't it? So when judges do so, the appellate court has no problem being like, oh, you should have ruled this way. They do it all the time. But a lot of the times you don't get things that overturn a jury verdict. It's a quite extreme remedy to overturn a jury verdict. So even if the court's like, even if arguendo, this ruling should have been that way, we don't find that it's dispositive. We don't find that it impacted the trial enough to overturn a verdict. Overturning a verdict is an extreme remedy. It happens. Cases get sent back they get remanded back to court, but not always remanded back for a new trial. Often it's remanded back to fix something, to resentence something, to redo the awards and things like that. But we'll see. So I don't question, what would Amber Heard even get out of a second trial? I don't know. I mean, maybe it's why the PR campaign is so hard right now, that if they do on any chance get another trial, they've maybe shamed the public into changing their opinion on how this case went. I don't know. I don't think a second crack at the apple is going to help. I really don't. I just don't. I also don't think they're going to get there. So, was the dispatch log in evidence? I don't know if it was. I truly don't remember. I know that the officers talked about it, but I don't remember if the log was in evidence or not. All right. And with that, we're going to get to questions in a minute, I swear, at 2 hours and 18 minutes. And we're going to talk real quick about this first Girardi case. Oh, I forgot to give you the poll results. Oh, no, I did. I did that. I gave poll results. We're going to swoop. We're going to talk Girardi real quick, and then we're going to move on to questions. Emily, do we just stream for 3 hours now? Kind of. And we didn't get to stream on Tuesday, and I missed you guys. So Emily, you sound stuffy. Are you sick? No, there was a ton of cat hair in my office today because the paw nerds have set themselves up in here, and some days it makes me a little bit stuffy. I am mildly allergic to cats. Sometimes it gets to me, sometimes it doesn't. Also, there are some times when I'm drinking that I get a little stuffy, so it happens. But no, not sick. Just my office. I need to vacuum in here tomorrow. The paw nerds were literally everywhere today. If you follow me on Instagram, you saw all of it. These cats, man, I tell you what, I should swoop again. We're talking about Girardi. Damn it, I got off topic. Erica Girardi, Real Housewife of Beverly Hills, has been sued again. Not in the bankruptcy court, like in another court. So we're going to go through it just real quick. We're not going to do a deep dive into this today. If y'all want a deep dive, we will. I'm very interested to see if this sticks. This is not regarding Tom Girardi. This is regarding other lawyers at his firm who allegedly did not pay a client. This is also filed by Twitter commentator, hater of Erica Girardi, or at least it seems to be based on the twittering, Ron Richards. So it's not a surprise to me that this case involves Erica Girardi. It's not a surprise to me that Page Six had this case well before it hit the court's website, but it was filed on July 15th at 12:29 p.m. in Los Angeles at Stanley Mosque. So we're going to go through it. The headlines on this case we covered last Friday. Now we've got the actual filing, and we're just going to go through it. Christina Fulton, an individual, versus Erica Girardi, an individual. EJ Global, an LLC. Pretty Mess Inc., a corporation. Samantha Gold, an individual. John Kelly Courtney, an individual. And Doe's 1 through 25. Some of these are attorneys. Complaint 4. I love that California requires this. I need all jurisdictions to do this. Look, I need all jurisdictions to do this. It makes it so much easier. It makes it easier for the judges. It makes it easier for me. It makes it easier for the research attorney. Just put your causes of action in your header box. It makes it so easy. It makes it so easy. Receipt of stolen property, conversion, constructive trust, money had and received, accounting, unjust enrichment, declaratory relief, breach of fiduciary duty, breach of contract, professional negligence, legal malpractice, fraud, breach of settlement agreement. Let's go. The parties. Plaintiff Christina Fulton is, and at all times, material here too, was an individual residing in Los Angeles, California, is an innocent victim of the fraud and theft perpetrated by Thomas Girardi and his wife, Erica Girardi. Tom Girardi is not named in this. Neither is Girardi Keys. Miss Fulton is a well-known Hollywood figure who has a child with Academy Award-winning actor Nicolas Cage. What? Look, I get it. But why is it needed in here? Why is the fact that she's the mom needed when we're talking about a breach of contract conversion case? Like, why is who her child's father is even relevant? I feel like the clickbaitiness of this lawsuit is starting out strong. The chat is like, what does Nicolas Cage and his child have to do with this? Literally nothing. Like, I think literally nothing but headlines. We saw this coming. Page Six got it right. Page Six did put it in the headlines. The headline was like Nicolas Cage's girlfriend sues Erica Girardi or some shit. It's not my choice. It just seems excessive and icky. Like, what? Why is it necessary other than to get the press interested in this case? Sarah New, why does it feel like RR is personally invested in Erica? Yeah, it very much feels like that. Look, for a quick brief, Richards was a part of the bankruptcy as the bankruptcy special litigator. He says that he left. Others have said that he was fired and yeeted. Unknown. He has also recently made headlines saying that he is buying the Girardi estate and fighting with Erica Girardi on Instagram, and then his wife fighting with Erica Girardi on Instagram. Like, all of it has gotten to be a lot. I have covered the stuff that went back and forth when Erica Girardi's lawyer tried to have Richard yeeted prior to his eventual yeeting, over stuff he was doing on Twitter, and the court was like, I'm not dealing with any of this. No. And then he was removed as the special litigator. There is so much history there that is covered elsewhere, but just there's a lot there. But the clickbaitiness is trying our collective nerve. I mean, really. It really does feel like it. Also, when we're talking about Nicolas Cage, he's only in the news at my house because my child is outraged that National Treasure has been announced without Nicolas Cage being involved. Because National Treasure is, in fact, a cringy, amazing National Treasure, and we love it. And so my kid is like, stop it. Just, you can't do this. He's so deeply offended. So deeply offended. Okay. Upon information and belief, defendant Erica Girardi, also known as Erica Jane's addiction. That's the collaboration I need to see happen. Like, it's my brain. Can you see it? I need I'm sorry. The people who do the music mashups, I'm gonna need, and it's expensive to be me, and a been caught stealing mashup. That's Erica Jane's addiction. I'm going to need that to happen. I'm sorry. I tried to get the thought out, but it was so funny in my head that I couldn't say it until I could breathe. But I need an expensive to be me, been caught stealing mashup, please. I don't even know if that would musically work, but my brain is so amused. My brain is just so amused. Erica Jade's addiction on tour. I mean, just okay. My brain. I've recovered. Sorry. Upon information and belief, defendant Erica N. Girardi, also known as Erica Jane. I call her EJ sometimes, or Erica Jane. So chat. Sasha says, yes, she's been caught stealing. All right. Smack your hand, Emily. Bad Emily. I can't. There's times I just can't. It just, that's, look, Been Caught Stealing was one of the songs we used to swim to with underwater speakers. I have very fond workout memories of Been Caught Stealing and other Jane's addiction. The 90s is the best era for music. Don't fight me. It's like my opinion. Okay. Upon information and belief, Erica Jane is at all times material here too, an individual residing in California. Erica is the wife of Tom Girardi. I mean, a strange wife, but cool. Owner and controlling member of the Girardi Keese law firm. Well, owner and controlling member of the now defunct and in bankruptcy Girardi Keese law firm. Tom Girardi is the founder of Girardi Keese. The firm served plaintiffs primarily personal injury suits, people who needed representation because they had been badly injured or were surviving family members of someone who had died. The Girardi Keese law firm operated one of the largest criminal racketeering enterprises, as alleged first by Edelson PC. The Girardi Keese law firm operated one of the largest criminal racketeering enterprises and stole more than $100 million from its clients. Again, just a reminder, lawsuits are allegations and shade. Lawsuits are allegations and shade. These are allegations. You can say this is alleged in this lawsuit, but y'all can't just go out and be like, Girardi Keese. Well, Girardi Keese probably won't sue you, but still, don't do it. Don't do it. All right, I've got to blow my nose. It's making me crazy. I'll be right back. No, that's not what I want to do. I want to do this. I feel so much better now. Skoda said, I've been listening to 90s alt rock all week. This has been kind of a Metallica week for me. It's been really good. Okay. Plaintiff was one of the firm's clients who was unfortunately a victim of the fraud and theft. My first question is, shouldn't this be in the bankruptcy? Shouldn't there be a bankruptcy claim? Shouldn't there be a bankruptcy claim? Yes, there should. There should be a bankruptcy claim. Sorry, look, the wheels have come off in the 2.5 hour mark. Shouldn't this be in the bankruptcy? If you are a client who was stolen from, it should be in the bankruptcy. But this is why I think they are alleging this against Erica, EJ Global, Pretty Mess, Samantha Gould, and John Kelly, Courtney. None of these people are subject to the bankruptcy. Girardi Keese is subject to the bankruptcy. Tom Girardi is subject to the bankruptcy. But none of these individuals are subject to the bankruptcy. So it's probably why they're the ones being sued. Or at least part of the reason they're the ones being sued. Oh, let's see. Upon information of belief, defendant EJ Global is, and at all times material hereto, a California LLC with its principal place of business located, and then the addresses. EJ Global was formed and in 2008 is exclusively owned and controlled by Erica. Defendant Erica is the only manager and sole 100% member of EJ Global. Defendant Erica filed her income for EJ Global on Schedule C of her personal tax returns for many years because she was the sole owner and member of EJ Global. Since at least 2008, defendant Erica was the only manager of EJ Global. The articles of organization shows that EJ Global, the company, was managed by Erica. Defendant Erica was the only one in control. EJ was created for the purpose of funneling money from Girardi Keese to benefit Erica, they allege. Plaintiff is informed and believed, and on that basis alleges therein that at all times mentioned herein, defendant Pretty Mess, PMI, is a California corporation conducting business within the jurisdiction of this court, was formed in 2021 as a successor entity to EJ Global, and is owned and exclusively controlled by defendant Erica. Well, EJ Global at that point had been sued a number of times by 2021 in connection with the unraveling of all of this. Defendant Erica is the only officer and director of Pretty Mess Inc. and it was formed by her business manager, who was referred to her by Lisa Rinna. But why though? But why though? It's giving Elaine sitting at a sleepover being like, but oh my God, she started dating so-and-so, but she only met so-and-so because of so-and-so and so-and-so and so-and-so were dating at the time. And then they met and then they started dating. And oh my God, can you even? It was formed by her business manager, who was referred to her by Lisa Rinna, a castmate of Erica's on her television show, The Real Housewives of Beverly Hills. For real. Was the vocal fry appropriate? I feel like that was an appropriate level of vocal fry for what we're talking about. Plaintiff alleges that in order to avoid large liability to EJ Global and its alter ego, Erica Girardi, Erica incorporated PMI as a personal services company, just like EJ Global, and has diverted her going forward income to this entity to avoid creditors of EJ Global and Erica Girardi. PMI is a mere continuation of EJ Global, so they're trying to pierce the corporate veil to get to Erica's income or assets. A personal services corporation using the same expenses previously paid by Girardi Keese. Erica is the same 100% owner of both companies. They're saying the formation of Pretty Mess Inc. is for the fraudulent purpose of escaping liability for EJ Global and Erica's debts. Specifically, it was only after Erica left Tom Girardi and Girardi Keese stopped paying for EJ Global and Erica's debts did Erica incorporate PMI, which does nothing different than EJ Global. Well, it's a different corporate structure, and EJ Global was being sued, so there might be other reasons too, but okay. Both entities are tax pass-throughs to the same beneficial owner, Erica Girardi. Erica is the alter ego. This all goes to trying to pierce the corporate veil and get to it instead of being blocked by the corporate entity. So Erica's the alter ego of them. Plaintiff further alleges that the entities are completely shell entities, have no capital in them whatsoever, have a single owner with no separate books, current bank accounts, or other indicia of corporate formality. Y'all, don't commingle your money. If you're having a corporation, you gotta have a whole ass corporation. And again, this is what's alleged. But if you're having a corporation, you have to have a whole ass corporation. It's gotta have its own shit, including its own books and bank accounts. It's got to do the things. These are just two entities Erica used and continues to use to avoid culpability. The companies all meet all requirements for an alter ego finding. Plaintiff alleges that all payments and monies received by Erica were via her American Express card issued to her personally with her own number, and vendors picked by her, and all the payments directed by her. This has wandered. The payments the firm keep the story concise. When it starts to wander, it again feels like oh my God, the payments the firm paid with the stolen settlement check can be traced to the payments made, which benefit Erica. But here's the thing. How is this all discovered? Was this all discovered during discovery, or was this discovered when Ron Richards was working in the bankruptcy? I'm just very curious how it's known. Like, how do they know? How do they know that the payments the firm paid with the stolen settlement check, whose stolen settlement? We've lost the story and the plot somewhere in the middle. The payments that the firm paid with the stolen settlement check can be traced to the payments made which benefit Erica Girardi. Huh? What I think is being said is that the settlement check that was supposed to go to the plaintiff here didn't, and was made and can be traced to payments made to the American Express that benefited Erica. I think that's what they're saying. Thunder Rain said, I'm too drunk for this document's rambling. I mean, Pam said, wait, we've gone from name dropping someone's baby daddy to Lisa Rinna to the American Express card. What is even happening? I know. This Noelle said this is to the theme of Here Comes the Hot Stepper, I think. Here comes the hot stepper. What am I? Okay, we're gonna keep moving. This has some big allegations. EJ Global is a company solely created for tax fraud. Okay, but what does that have to do with the plaintiff in this case? I mean, it's a big allegation. The Franchise Tax Board found that EJ Global was a not-for-profit company. The Franchise Tax Board, by the way, is like California's IRS wing, but you have to file not-for-profit status. I'm so confused about this sentence and why it's here. Erica personally participated in the tax audit, retained counsel for the tax audit, and has known since 2017 when the tax authorities questioned its tax status. What in the world? What is happening? Mom, can you pick me up? I'm scared. It's not even a separate paragraph. Okay. What audit? Regarding what? What? The tax audit was going up to 20. The tax audit was going on. The tax audit was ongoing. Sorry, there was no apostrophe. Not apostrophe, a hyphen. The tax audit was ongoing up till 2020, and the attorneys were representing Erica personally in that audit. Erica and Tom would deduct EJ Global's expenses that was on me. Erica Girardi Global's expenses on their personal tax return. Well, they filed a Schedule C, not a K1, which is interesting. Girardi Keese would keep the money paid to Erica as a bogus receivable on its books and records. What does any of this have to do? Like, can we tie it together to this plaintiff? We haven't tied it to this plaintiff yet. We're just like throwing mud at Erica, which, okay. But where is the like, what happened to this client? That needs to come before Lisa Rinna and everything else. Where is what happened to this client? So far, we know that plaintiff was one of the firm's clients who was unfortunately a victim of fraud and theft. How? What happened? Can we do that and then get into the rest of it? Because now we're all just confused. Plaintiff further alleges that the entities EJ Global and PMI are completely shell entities and have no capital in them. I think I've already read this. I hope so. We're moving on anyway. Erica and Tom would deduct EJ Global's expenses on their personal tax returns. Girardi Keese would keep the money paid to Erica as a bogus receivable on its books and records. Erica clearly knew that for the tax years 2011 to 2013, the FTB found that the entity was created as a tax avoidance entity. How do we know this? I want to know more. I have questions. Holy said this lawsuit has more tangents than a Peter Mon video, which I love so much about him. I love that so much about him. But you guys are all like, I'm not sober enough for this filing. I'm lost. It's not you. This filing has wandered out from under us, and we're just like, what is happening? It's not you. It's not you. It's the filing. It's just, what? Okay, so they're alleging that Erica knew that the Franchise Tax Board of California found that the entity was created as a tax avoidance entity, which may or may not be true. Fine. How do you know? Why does it matter? To make matters worse, on Erica and Tom Girardi's Schedule C, they would deduct all the expenses the law firm paid EJ Global's as a business would deduct all the expenses to the law firm paid to EJ Global as business expenses to go against their personal income. These double deductions are highly improper and fraudulent. Tell the IRS. Which, if these things are going on, it's going to go to prove what I've been saying since the beginning. No matter what we see in this, the IRS will probably get the last word. EJ Global simply, why can't it just say was simply a conduit? EJ Global simply was a conduit to deduct their personal lifestyle expenses. Okay. The law firm had no business paying EJ Global's expenses. Oh, probably true. And will never get repaid the receivable. But why does it matter what, if the law firm gets the receivable back, we're not in the bankruptcy. We're not in the bankruptcy. What is more egregious here is that they used plaintiffs' misappropriated settlement funds to fund their personal lifestyle. There it is. Why are we burying it under all of the tax and Lisa Rinna bullshit? Lead with that. Upon information and belief, defendant Samantha Gold is an individual in California. At the time Girardi was retained by plaintiff, Gold was an associate at Girardi Keese and worked on the file and represented plaintiff. Okay. Ms. Gold is currently an associate at Axe. Oh, that's interesting. Axe, Abir, Cohen, Trazion, and Salo is also involved in the bankruptcy because Axe is another plaintiff's firm that has taken on some of the Girardi cases. Axe actually got sued. I need to go back and look at what happened with that. Axe got sued early on by the bankruptcy trustee over taking over Girardi clients before the bankruptcy trustee handed them over. Interesting. The firm is presently the special counsel for Jason Run, the trustee of Thomas Girardi, which makes it more confusing that the trustee for the law firm bankruptcy, the Girardi Keese bankruptcy, was suing the special litigator for the personal bankruptcy. When we talk about the messiness, there's messiness. Okay. Which is noted. The firm is presently the special counsel for Jason Run, the trustee of Thomas Girardi, and is being sued by Elisa Miller, the trustee for Girardi Keese, over a fee dispute. Axe also has brought a counterclaim in that action. Well, I appreciate the tea and the refresher. It's refreshing tea. I don't know if it's super relevant. It's interesting. Well, let us go on. Defendant John Kelly Courtney is an individual residing in Los Angeles, was a senior attorney working on the plaintiff's file while at Girardi Keys, is now employed at ADR Services. The true names and capacity of, okay, great. But what happened? Okay, good. Fact allegations. Great. In 2016, plaintiff retained Girardi Keys and Tom Girardi, that was a while ago, to represent her in connection with claims based on severe injuries she sustained in an automobile accident on or about January 1st, 2016. That sucks. Girardi's representation resulted in a confidential settlement agreement dated March 18th, 2019. Okay, so 2019. So right around the time that all of this just about cracked open. That's unfortunate. The settlement agreement provided for a release by plaintiff in exchange for a consideration of $924,000. Well, it's not a private settlement anymore. So the settlement agreement was for $924 some odd thousand. Gold was plaintiff's point of contact and the primary counsel on plaintiff's case. There are numerous communications from Gold to third parties indicating Gold had knowledge of the medical liens and disbursements of the settlement amount. Gold signed the settlement agreement above, acknowledgement of confidentiality and non-disparagement, and consent to be bound by the same. Great. Courtney was the senior attorney working on the file. He was included in the emails. The details and dates of where plaintiff settlement funds went were just recently discovered through newly discovered financial documents. Okay, but some of these things have a very short statute of limitations. So if this was filed, I worry for the client who has not gotten paid about the statute of limitations here. They are alleging that it was only recently discovered, but didn't you know you didn't get paid? I have concerns. I think that we will see that come up in the answers. I think that all of the clients who didn't get paid should get paid. I think that statute of limitations will be an issue. We will see. But they are saying it was only recently discovered, but wouldn't she have known she didn't get paid? I've now said that twice. Let's see. The details and dates of where plaintiff settlement funds went were just recently discovered through newly discovered financial documents. The filings is redundant as I am, which is great. Great. We can just lop one of these out. Plaintiff did not know where her money went until now. Okay. I'm not going to start singing Robert Palmer. I'm tempted. But even if the plaintiff didn't know where the money went, the plaintiff would know that the money didn't go to her and then could have sued Girardi Keys, but then all of this went down. Law and Lumber's like statute of limitations are stayed during bankruptcy. The thing is, though, yes, but they're not suing in the bankruptcy, and they're not suing anyone subject to the bankruptcy. This is suing non-bankruptcy parties. They're suing the individual attorneys, not the firm, and they're suing the wife who's not in bankruptcy. Erica Girardi's not named in the bankruptcy. They're not suing Girardi Keys, which is potentially also a problem. If they were suing Girardi Keys, then it would be swooped into the umbrella of the bankruptcy. They are, I think, trying to stay out of the umbrella of the bankruptcy, suing everybody else. So we will see. Which is going to be hard because it's ultimately the law firm that didn't pay her, even though these were the attorneys working on the case. Ultimately, the law firm is responsible, but we will see. I'm interested to see what their theory is that the law firm is not responsible. On July 14th, 2022, plaintiff discovered that all of her remaining settlement funds were dissipated and that her Girardi Keys attorneys, Gold and Courtney, had lied to her. On July 14th? This was filed on July 15th. What? I'm confusion. How was this discovered a day before this was filed? I'm confused. Okay, keep reading, Emily. Just keep reading. On July 14th, 2022, plaintiff discovered that all of her remaining settlement funds were dissipated and that her Girardi Keys attorneys, Gold and Courtney, had lied to her. It was just discovered how the settlement payment was made. Well, if it wasn't paid to her. On March 29th, 2019, the settlement amount was issued to Girardi Keys and Christina Fulton. On April 8th, 2019, the check was deposited into Girardi Keys' Nano bank account ending in 0567. I wonder how they know that, because I don't think they've done discovery yet. The check was, quote, to be deposited in trust for Christina Fulton. I'm sure it was. It was client settlement funds. This was a complete outright forgery, as plaintiff never endorsed this check and certainly never agreed to have it deposited. The check was to be deposited in trust for Christina Fulton. Are they saying somebody wrote that as if it was her? There's information missing that's very confusing. This was a complete outright forgery, as plaintiff never endorsed the check and certainly never agreed to have it deposited. The Girardi Keys firm had the audacity. Well, there it is. We found it, y'all. We found it. We found it. We found the audacity. Nope. That's not the one I wanted. That was too loud. Sorry. We had to go find the audacity. There it is. We found it. All of you in the chat that are thinking that you're more intoxicated than you are, you're not. This is confusion. This is confusion. You are not that intoxicated. It is this. But we found the audacity. For everyone who fell asleep, I apologize. My bad. All right. The negotiated check was in fact a forgery and a lie. I think they're saying that not the underlying check was a forgery, but the endorsement of the check was a forgery, because if the whole check was a forgery, then who got the money and where was it stolen from? The check was never held in trust but spent. It is beyond shocking and the pale that the firm would conceal the arrival of the check and not obtain Ms. Fulton's endorsement as required by law. Are they trying to be cheeky, or is this sentence confused? I think this sentence is drunk and needs to go home. I don't think it's cheeky. I think they're trying to say it's beyond the pale, but they're saying it is beyond shocking and the pale that the firm would conceal the arrival of the check and not obtain Ms. Fulton's endorsements as required by law. Look, I'm here for a cheeky, shady filing. I'm here for it. I am here for cheeky and shady. But I am not here for mixing metaphors. Look, if it's beyond shocking, stick with that. If it's beyond the pale, stick with that. Don't try to mix them. Keep the snark concise and sprinkle it like Ben Chu. Like Salt Bae, just like sprinkle the snark. Like too much snark is just overdone. You know? When a plaintiff settles a case, the funds are to be held in the lawyer's client trust account. CS Verdad. The lawyer then deducts the fee that was agreed upon with the client, and the remainder is typically remitted independently to the client, which is what is legally required. Well, yes, they take the fee, and then they take the costs, and then they give the rest to the plaintiff. Unfortunately for plaintiff, this is Girardi Keys. This is Sparta. And that is not what happens. That is not what the fuck seems to happen. Unfortunately for plaintiff, this is not what happened here. Instead, attorneys other than Tom Girardi. See, they're trying to keep this out of the bankruptcy. They're trying to keep this out of the bankruptcy. They're trying. They are trying. They are trying. Instead, attorneys other than Tom Girardi, who were working on her case, failed to even obtain her signature on the settlement check, which shouldn't have happened. But ultimately, I think the firm is going to be the problem. Then made and joined affirmative representations to others that the funds were still being held in trust or held in the trust account. It will... What is happening? It will not be enough to say that even though they represented the money was in the account, they were relying on Girardi Keese when they made those representations. There were no qualifiers in the written representations. They're trying to counteract the arguments that are already coming, but it's confusing. Somebody's asking, did I just say CS Verdad? I did. Yes, I did. Yes, I did. I grew up in Southern California. Sometimes it just happens. So love Emily speaking Spanish to make more sense of it. Sometimes it needs to happen. We've slipped into chisme telenovela territory. So, I mean, it just makes the most sense. Okay. I think they're trying to shield the arguments that are coming, but just argue the arguments when they come. Because that's what they're going to say. What they're going to say is, we were working for Girardi Keese. It's on the firm. Numerous attempts were made to obtain records, emails, and information regarding the other attorney's role. When? The attempts were literally ignored except for one email after weeks of requests by one of the attorneys stating... Numerous attempts were made to obtain records, emails, and information regarding the other attorney's roles. Like, some other guy was just like, and I was like, we need the records and emails. The attempts were literally ignored except for one email, like weeks after requests by another one of the attorneys, like some other person, stating that a response would be forthcoming, but knowing that this lawsuit was imminent. Like, what are they even doing? But how did they even know this lawsuit was imminent if this was all discovered the day before the lawsuit was filed? But I digress, because like, the plaintiff deserves more then and deserves more now. Like, attorneys, whether they are associates or partners working for the firm, still have like a duty to their clients. They can't simply avoid legal responsibility by blaming their employer. Like, we totally know that's what they're going to do in their answer. They're for sure going to blame their employer, but like, their employer's in bankruptcy and we don't really want to have to deal with the bankruptcy, because if we have to deal with the bankruptcy, we're going to be at the back of the line. And I don't know what the cutoff date was for creditors. And I don't know if this person has filed a creditor, but like, we don't want to do that. We want to sue Erica because like, she has earrings. So the law does not provide immunity for attorneys representing clients through a firm versus directly. There is no such distinction. So like, don't even bring that defense here. We're suing you personally. Too bad. I think this is all going to end up under the firm though. Okay, let's see. Between April 2019 and September 2020, Girardi paid plaintiff. At least some. Somebody was saying, now it makes sense. Thank you. I'm glad we've made it made sense. Somebody's like, it sounds like they're trying to jump the payment line. Jump in line. They're trying to get to other sources of funds because these attorneys are not in the bankruptcy. Erica's not in the bankruptcy. They're trying to get to other sources of income, which, you know, zealous advocacy for your client. Your client got screwed. Your client didn't get paid by their attorney. That's not fucking cool. I understand. I just don't know if that's going to work. Between April 2019 and September 2020, Girardi paid plaintiff mostly through a litigation funding company a total of $190,000. The last check plaintiff received from Girardi was in September 2020. Slightly before literally all of the shit hit the fan. This was part of a lulling pattern of Tom Girardi. This was part of the lulling pattern of Tom Girardi to dupe his clients into waiting for money by dribbling small bits. Payments. The dribbling is sending me. But yes, that seems to be exactly what Tom Girardi did, was like, here's a bit, it's coming. It is typically used in a fraud scheme by criminals. I remember when I suggested that this all felt very much like a Ponzi scheme. at the beginning of this whole thing, you give a little bit of payment in the scheme to keep people from complaining. In addition, prior to the settlement, Girardi advanced plaintiff $5,000. After crediting the $195,000 that plaintiff received, the outstanding balance of the settlement amount that is still due and owing to plaintiff from Girardi is $744,000. So after the costs, after the legal fees with the settlement, after what's been paid, $744,000. In May 2019, Gold misrepresented to another attorney. What other attorney? Who? What? Like Gold told some other guy that the settlement funds had not yet been deposited. What other attorney? Did the plaintiff get another attorney to talk to her attorneys? In May 2019, Gold misrepresented to another attorney that the settlement funds had not yet been dispersed, meaning Girardi Keese didn't have them yet. When in fact 3 checks were dispersed to Girardi, $214 on April 26, 2019, $100,000 on April 12, 2019, and $300,000 on April 10, 2019. A true and correct copy of Gold's written misrepresentations are attached as Exhibit D. Oh, good. Courtney was included in these communications and never corrected Gold that the money had in fact already been dispersed, which is fucking appalling. I just don't know what Erica had to do with any of that. The attorney shouldn't be doing that. On July 14th, plaintiff discovered this fraud and that her settlement funds were dissipated within days upon receipt. How? How was this just discovered on the 14th? Plaintiff repeatedly demanded that Girardi remit the remaining settlement funds that she was owed. I bet she did. Where's my money? Girardi personally promised plaintiff that she would receive the money. Up here it says other attorneys, not Tom Girardi. Down here it's Tom Girardi. I think this is all going to get swooped up into the firm. We'll see. Girardi personally promised plaintiff she would receive the money, assuring her that her money was safe in undisclosed accounts and investments. Why? You're not investing money for your client without their approval. You're putting it in a trust account and then you're giving it to them. But if she was told that it wasn't received, in May 2019, she was told it wasn't received. Like the firm didn't have the money yet. And then at some point, Girardi personally promised her she would receive the money and that the money was safe. When was that? I need the date on that. When did that happen? On December 18th, 2020, involuntary bankruptcy proceedings were initiated for both Tom Girardi and Girardi Keese. The bankruptcy filings show Girardi Keese owes more than $100 million to creditors, including Tom's personal injury clients, lenders, and other attorneys. On April 4th, 2021, plaintiff filed Fulton versus Girardi in the bankruptcy court seeking to have her claim against Girardi declared non-dischargeable in Girardi's individual bankruptcy case. So she filed a claim on April 4th, 2021. Mathing isn't math. On April 1st, 2021, in the personal bankruptcy. November 16th, 2021, the bankruptcy court entered a non-dischargeable judgment against Tom Girardi and his conservator in the amount of $744,650, including a $350,000 or $350 judgment in costs on plaintiff's second amended complaint. A true and correct copy is attached. Okay, so they got a non-dischargeable judgment against Tom Girardi in the bankruptcy against his personal estate, of which there seems to be dust. So what's confusing to me is the conflict that would ensue, potentially, or the appearance, if Ron Richards is going to get paid on this. I don't know if he's also the attorney on the other one that was filed in the bankruptcy. But if he's the one that buys the house, and the money from the house goes into the personal estate and then gets paid out, is he just paying himself through the bankruptcy? I just don't know what's happening. I have so many questions. But so this plaintiff got a non-dischargeable judgment against Tom Girardi for $744,000 and is now going after the other attorneys and Erica for that same amount of money to try to find them all jointly and severably liable. Interesting. And went after Girardi personally and not the law firm, because law firm probably back of the line. We'll see. But this was, I guess, whatever they discovered in July was like, oh no, Girardi didn't have the money. On November 17th, 2021, plaintiff filed an amended proof of claim as to debtor Girardi Keys. Great. And debtor Thomas Girardi to confirm the judgment. Attached Exhibit C. Great. Plaintiff recently discovered through bank records and other financial documents that the settlement funds, well, they probably discovered it because they're now parties to the bankruptcy, which is new information that I would have loved to have had up above. Keep reading. This is why you keep reading. Let's see. Plaintiff recently discovered through bank records and other financial documents that the settlement funds were diverted to Erica via EJ Global, and the intellectual property and value transferred to EJ Global was transferred to PMI. Huh? Okay. I need more explanation. Plaintiff is informed and believes, and on that basis alleges that as Girardi's client's case is settled, Girardi would receive settlement funds, and in turn, Tom and Erica would use those funds as their own assets. Tom and Erica would use those funds to pay for their lavish lifestyle. The funds were treated as community property. Erica used the money to pay off her expenses. For at least 12 years, all of her expenses were paid by Girardi Keys as she was generating them. No one withdrew money from the firm other than Erica Girardi. She was getting her American Express bill paid. I don't think she was withdrawing money from the firm. Like, I'm interested to see how that is substantiated. But Tom Girardi was taking money out of the firm. We saw the checks in other filings that he was like writing checks directly out of the firm to jewelers for the earrings and shit. Plaintiff is informed and believes and thereon alleges that Erica had all of her expenses paid for her by the firm directly. Over $25 million in expenses was just spent on her on the Girardi Keys books. Okay. Plaintiff is informed and believes that plaintiff's settlement funds were remitted to Girardi Keys and were misappropriated to support Tom and Erica's lavish and high-end lifestyle. The newly discovered documents show Erica misappropriated plaintiff's remaining settlement funds. Plaintiff's settlement funds were used to pay the balances of the American Express credit card bills or charge cards used by Erica and her companies. These were all personal expenses of Erica's being paid off using plaintiff's money, which should never happen. I don't know that Erica knew that. We'll see. Question, is the firm PMI? No, as we established at the beginning, Pretty Mess Inc. is PMI and EJ Global is EJ Global. EJG and PMI. PMI is Pretty Mess Inc. In 2019, Erica, via her solely owned LLC, received $407,000+ from Girardi Keys. Her receivables grew as well. This is the same year plaintiff was to receive her settlement funds. Erica misappropriated plaintiff's settlement funds. The facts speak for themselves. I'm still unclear. Did she receive the exact same amount? Did we trace the checks? Okay. I mean, I don't doubt that the client never got her money. It's just how it's traced I'm still confused on. Plaintiff has not received any funds from Girardi since September 2020. I'm not surprised by that. Newly discovered evidence shows that Erica, using her shell entities, stole plaintiff's settlement funds by having received stolen proceeds from the converted check funds. If they can trace it, it'll be interesting to see. This is how she supported her luxury lifestyle. Bank records show that the settlement funds went to Erica. Erica used her shell companies. Well, if the funds went to her, what's the shell company matter? I mean, if the funds just went to her, what do the shell companies matter? But okay. Here's my beef. If they're alleging it went to the companies, say the money went to the companies and then was used by her as personal assets. If you're alleging it went by her, stop talking to me about the companies. Who got the money? It's not going to be both. Did the companies get it and she spent it, or did she get it directly? Erica used her shell companies to hide assets and evade culpability. Plaintiff is entitled to the remaining settlement funds of $744,650. Plaintiff is seeking to recover her settlement funds that were used on Erica's expenses for Erica's benefit. But if Tom's the one that paid them, I think the remedy's already been secured in the bankruptcy court, which is unfortunate because the client deserves to be paid all of her money. In all of this, the client deserves her $744,000. But so do all the other clients in the bankruptcy. And I don't think they're going to be able to get it back individually from the other clients. And then we've got the causes of action for the receipt of stolen property against Erica and her companies. And that's receiving the funds from Tom, which, if they can trace it, might be their strongest cause of action because you don't have to show that she knew. You just have to show that she received it. Second cause of action, conversion against Erica and the others for using the funds that were purportedly from this client. Third cause of action, constructive trust, meaning put it in a trust so it can't be spent. Fourth cause of action, money had and received against Erica and her companies. Fifth cause of action, accounting against Erica and her companies, forcing an accounting on them. Okay. Sixth cause of action, unjust enrichment. It wasn't yours. Give it back. Seventh cause of action, declaratory relief. Let's see. They want a declaration that an actual controversy exists. So, hey, Your Honor, can you please say that we can all go here. So let's see. Eighth cause of action, breach of fiduciary duty against defendants. I mean, the lawyers should have made sure that none of this shit happened at all. Breach of contract against the defendant lawyers. In 2016, plaintiff retained Girardi Keese and Tom Girardi to represent her. Yeah, they shouldn't have taken her money. 10th cause of action, professional negligence, legal malpractice against defendants Gould and Courtney. I don't know how the statute of limitations will work on that, but we'll see. 11th cause of action, fraud against the lawyer defendants. I want to see the emails that are attached. 12th cause of action, breach of settlement agreement. Yeah, you're supposed to give the money to the client, and they didn't. Let's see. They're seeking the costs. They're probably going to seek legal fees, fines, whatever else the court just deems just and proper. I want to get to the photo album. I want to get to the photo album. I want to get to the photo album. What? There's a y'all. I wasn't expecting that. I just wasn't. In a car accident breach of contract case, great. I mean, I expect a photo album in like a trademark case. I like that the Getty Images watermark is still on it though. Okay. Your Honor, this is the plaintiff. Somebody's like, I just saw Emily's brain short circuit. Yes, because I was really looking for the emails. Yes, I'm guessing this is the plaintiff. Okay. We're just okay. Is this photo watermarked? Oh, it is. Wait, this one is still watermarked. Fantastic. Okay. Wait, this one, nope, that's actually aloe. That's not watermarked. I was like, wait, is this one watermarked too? Great. Where are the exhibits? Let's get to the exhibits. Please, God, please get us to the exhibits. Please get us to the exhibits so we can get to questions. Let's see. This is the claim filed in the bankruptcy from November 16th. Proof of claim. Great. Exhibit A. This is probably more facts that are maybe a bit more succinct, which would be great. But, lawsuits are allegations and shade. This is the transaction for that. Great. We'll come back. Exhibit A, where are the communications? That's what we are looking for. There we go. Samantha Gold, May 21st, 2019. Our former client, Christina Fulton. This is going to another lawyer. And CC'd. You are correct that the matter has settled, but it appears that Mr. Girardi's offer to provide you with a 25% fee was withdrawn upon the filing of your lien. Oh, shit was going down back in 2019, as communicated to you in writing in June of 2016. Accordingly, please provide my office with information about the services you rendered to Ms. Fulton in this case, including but not limited to the amount of hours allocated. Okay. Exhibit 3, email from Samantha Gold, same attorney. They were emailing an attorney. Dear attorney, please be advised that the matter settled for the sum of $924,000. However, Fulton's recovery will be drastically reduced due to the numerous medical provider liens exceeding $450,000. Medical provider liens, by the way, are, hey, after that car accident, any settlement money goes to pay them back first. Ms. Fulton treated virtually exclusively under lien agreements for the injuries sustained in the subject collision. Further, the litigation was ongoing for over 3 years, resulting in substantial case costs for multiple depositions, mediations, etc. Monies have not yet been dispersed. So monies have not yet been dispersed to Girardi Keese or dispersed to the client. I think there's a little bit of question in the meaning there. This is from the attorney that's trying to get the money. Hello, following up again. Please provide me with settlement information by close of business today. This is our fourth request. Thanks. So this attorney was going back and forth, it seems, trying to get information for the underlying plaintiff here, which to get an attorney originally and then have to get a second attorney to yell at your attorneys to pay you would be very, very frustrating. It'll be interesting to see what the answers here are. It's going to be difficult for these attorneys to deal with this because I imagine all of their records are still with Girardi Keese with the bankruptcy trustee. So they're going to have to get to all of their, records first, which are probably kept with the former law firm. And then they're going to have to deal with this amount, how much this amount is supposed to be. We've now been live long enough that the porn bots are out. Wonderful. So with that, we will see what happens. I imagine that the answer will be, it's Girardi Keese's issue, not ours. And that it is, we need to get access to the books and stuff that Girardi Keese has, et cetera, et cetera, et cetera. So that's very interesting. We'll see, but a lot of it reads like just throwing Erica under the bus. I don't know how all the tax stuff is relevant. I wonder if their argument will be, well, no, it's relevant because it shows it's a shell company to pierce the veil. Maybe. We'll see. The responses will be interesting. I think they'll try to pull it back under the bankruptcy. The bankruptcy court has already ruled that Girardi owes this amount. I don't know if these attorneys will challenge that amount and say, no, there were these liens and this stuff. What was distributed, the amount, the 100,000+ was all that was to be distributed. I don't know. I can see where there will be arguments on this. This is not just a cut and dry, but there is a photo album and some name dropping. And so, the clickbait value is there as well. I'm going to get to as many questions as I can in the time that we have. I've got questions. You've got questions. We've got questions. This was a long one. I didn't intend to go into this lawsuit nearly as much, But then it was like, wait, what the fuck is happening here? And then we ended up down that rabbit hole anyway. Apologies. So there we go. Thunder Rain, being sober is not going to help this at all. Just at all. This is a it's hard to follow the story because there's a bunch of stuff crammed in that doesn't go with the story. And that's why it's hard to follow. It's like, no, the story of litigation we need to understand. And that I want to know what they discovered. Like, what did they discover? And not even how, what did they discover and what does it show? So, Hempland, Texas, thank you for gifting memberships. The mods have let me know, and you gifted memberships yesterday during the premiere as well. That is so tremendously kind. Thank you. And to everyone who got memberships, welcome. We're going to get to as many super chats as we can. So, Thunder Rain said, I have a brilliant idea. I will send this to my D&D dungeon master and ask him to create a parallel dimension in which this makes sense. I would love to see what his creative mind does. I love that. Liv is inside again said, we'll be at the back of the line, had me dying. I mean, that's a problem. And it's a real concern. And the job of the attorneys is to do what's right for their client, not all the clients. It's their client. They are a zealous advocate for their client. Please, no more mixed metaphors. My head hurts enough. I mean, for real. Objection unintelligible, Camille Vasquez. There were moments. Not everyone can handle English or logic. The thing is, the lawsuit needs a succinct purpose, and there can be particularly footnotes of shade that are like, oh, and this and this and this. But the story of what's happening in this lawsuit needs to be succinct before the other stuff gets added in. That's where you lose or it gets lost. Hello, Law Nerd. Can we get an EDB music album? No. I am not a singer. I make parody jokes. I sing. I'm a memer. Now I have Steve Miller in my head. I'm a memer. I'm a reader. I'm a drinker. And I'm a chatter. Question, what is the story behind Move Your Head, It Binged? Izzy, that came from the day that we hit 100K on the channel. And Dr. B was sitting with me. And we were waiting for the binger, the counter back here to bing. And so he was looking at something and I couldn't see it and we couldn't see it on stream. And so I was telling him to move his head. It's just what happened. That stream is still on. So if you need the whole context of it, that stream is on the channel, the 100K celebration stream. But it binged and I was like, move your head. I was telling him to move his head because I wanted to be able to see this in screen. And I lost my mind. It was very exciting. It happened faster than I thought it would. And it kind of snuck up on me. And I was like, oh my God, we're going to hit 100K. We've got to go live. So I try to catch those big moments live as much as I can. We hit so many of them during the Depp and Heard trial coverage, but I try to hit them live and we will just continue doing it, as best we can. Shadow said, do they not know how to write a motion? Did they go to the same school as Elaine? It was just very hard to follow. I think it's because the information was not ordered the way my brain would order it. But it was hard to follow because we didn't know how the plaintiff was tied in. I prefer to put that at the top. So it was just very difficult for me to follow, but we will see. They're saying they just found out the information the day before. So it might just be that we found out the day before and we're filing suit today and speed might've had something to do with it. There might be internal concerns about the statute of limitations as well. We'll see. I went in on this case. Where can I find what you're reading? This is filed on the LA County Superior Court site. So this isn't LA County Superior Court, though I'm sure that Ron Richards has put it up on his Twitter. Like I'm sure this is also available elsewhere. So Lula said second super chat because I'm incompetent. Transcript on the bond hearing was in Heard's filing on keeping stuff sealed on 7/1. I will look for it. I haven't seen that filing, but I will. Hold on, let me make a note. You are not incompetent, but thank you. That is very good information. I will go look for it. Bond. I have to make a note or I will absolutely forget. Thank you. All right. Rob, I see all your super chats. I'm going to get to them in just a second. Question: Waldman's statement was made to the Daily Mail, which is published in London. So how does Virginia have jurisdiction in Amber Heard's countersuit? I did not look to see about the jurisdiction. I didn't see the early on motions about it. I don't know if they were arguing about it. I don't know if Depp had already availed himself to the jurisdiction. I'm sure there's motions about it. I don't remember how that was decided or what the court ruled. I remember the one for Heard because it was so substantial, but I don't remember. It's a very good question. Lawn Lumber said the lawsuit by trustee versus trustee is actually more common than you think. Clawback actions in closed corps happen all the time. Still crazy. It's slightly different because it's not trustee versus trustee. It's the bankruptcy trustee for the law firm suing, well, the special litigator for the trustee of the personal bankruptcy over the fact that they started representing clients from the law firm Girardi Keese that, well, I guess essentially that is kind of a clawback because it's like, well, these clients and the client agreements should go to us. It's kind of full tilt wild, but it's I guess, I mean, if you're saying that the special litigator stands in the shoes of the trustee, but it's trustee, special litigator being sued by the trustee and the other bankruptcy over clients. It's so weird because it's so many lawyers involved. Can you send me the lawsuit? Just email me, Rob. You don't have to super chat me. Co-debtor stay in bankruptcy often covers other principles. I'm curious and can probably get you. Oh, yeah, yes. Go just or DM me. Pterodactyl said, question, sent Rob Lawn Lumber a tweet and offered $200 to obtain what you guys feel are most interesting, important of the sealed documents from Judge A, but he hasn't answered. Would you care to assist in communication with that? Well, he's in the chat. I'm dying to know what's in them. If they are sealed, we cannot get them. But I know that Andrea Burkhart is crowdsourcing what is being unsealed. So those will become available because they are being crowdsourced. So the unsealed documents will be available. We are all curious, but I know that the community raised a bunch of money when Andrea put that out on Twitter. So that will happen. Will we be seeing you on Lawyers and Dragons? I have no idea how to play D&D. I have been invited, and when I can, I will. I just have a super busy next few weeks, which it's also the end of my kids' summer. So Saturdays and Sundays are, A, family time, and B, shopping, because my oldest has literally grown out of fucking everything he owns all the time. Just all the time. So questions: will you cover the Amber Heard insurance lawsuits? Yes, on a podcast episode that is in the works. You YouTube lawyers are so resourceful. All they basically teach you in law school is how to look at shit, how to research shit, and how to do shit. They don't really teach you how to practice law, but they teach you where to look for information. So lawyers are very good at looking for information. So Thunder Rain said the D&D community tends to be super friendly and willing to teach. All you have to do is find the time and reach out. Yes. I would, on Hoag's channel, he has started doing Lawyers and Dragons for D&D, but I will absolutely pop over there as a friend of at some point. I don't need a full place because time is hard. Question: are there any updates for Jeff Wittick and David Dubrick? And I know that's not how to pronounce his name. No, there aren't. Nothing has happened in that case yet. Can you please explain fiduciary responsibility in terms of the lawyer being separated from the bank? I would need more context, Wolf Rebel, but because we have not talked about Murdaugh at all. So when I talk about the banker who just got federally indicted, we will cover fiduciary responsibility again, but fiduciary responsibility is a type of legal duty. So you owe a legal duty. Like, I generally do not owe a fiduciary duty to just people running around. It is a particular type of legal duty that you owe based on a position that you hold. So like a lawyer's duty to a client is also a type of a fiduciary duty. So it is a legal duty that is owed. But I have not broken down stuff into the banker in the Murdaugh case and how that is all being flushed out and what is being flushed out and where the duty was breached in that. But yes, as we get back into Murdaugh, I will. Question, did you listen to Tamara Judge's podcast this week? No, I have not. Andrea already donated extra money to CHLA. I thought that she had sourced it all the way, which is good to know. Question, any update info on Aaron Brockovich and Beverly Hills High School? No, I have not had a moment. So, not yet. Amber Heard is going to pledge her $8.3 million on appeal. Possibly. I don't know if it'll fly with the court. Emily, please check Insta DM. On vacay, just sent a pic because Lawnards must know. Might have a word that rhymes with... P.S. I went to high school with Amy Van Dyken. Well, look at this. We've got a whole chat full of love for Amy. All right, hold on. Now I'm curious. Let's see. We will check. Do I often check DMs when told? No, but I try. Let's see. Oh, when was it sent? Danny, I hope that is actually your handle on Insta because there are, well, unfortunately, because I love you all and I get to as many DMs as I can. My DMs are swamped, and Danny, you'll have to let me know what your name is on Insta. If it's the same, I just don't see it. So if you want to send something real quick to bump it, then maybe we can bump it, but I do not see it at all. I'm sorry. It is the way of the Instagram. My DMs do get slammed. One of the best ways to have me see anything is to email it. It does go to somewhere where it can be shown to me so I can see things, and that makes it a little easier. So I will try to look again in a minute, but thank you for letting me know. Hello, Ottawa. We just found out our 4-pound Chihuahua is allergic to cats. I can't say that with a straight face. Your Chihuahua's allergic to cats. I love that. Your Chihuahua has aggressively said, no cats in my house. Thanks. We're not dealing with it. Kathy, did you get your million alpacas for JD bracelet? Not to change the subject. I did. I've been meaning to put them on my Insta and I have not had a chance yet. So I will. And Jeanette from Law and Crime was at the hearing for Depp and Heard on 6/24. I'll have to go check Twitter because I want more information. I think I got Wolf Rebel. I did the best I could on that one. Michelle said a question regarding Elaine Bredehoft. Seems so out of her depth that I kept wondering if she's more a plaintiff's counsel than defendants. Do you know? I don't know which side she normally represents. I do think most of her cases settle, and she is much more comfortable with depositions than with trial. I don't know how difficult her client was, but there was a lot that I did not love. I appreciate the update stream tonight. Well, I draft a sewing pattern for my Lord of the Rings drag costume. I'm tired of the Amber Heard Johnny Depp shit. Love the Lawnard fam. Call me Al. That sounds amazing. And I love drag so much. Let's see. New conga song. You must pay your bond before you file your brief. You must pay your bond before you file your brief. Oh no, I believe you. Sorry, I've just got Beetlejuice stuck in my head tonight. You must pay your bond before you file your brief. I can make anything work to that tune this evening. If Australia gets Amber Heard extradited for trial on perjury, will it put a hold on these appeals? Shouldn't. I mean, the appeals are just on the record. They don't technically need her for it. The bankruptcy attorney needs the Girardi updates. There's so many. Rob, it's so much. The bankruptcy records are so much. Mickey says the tone of your voice now is so soothing in comparison to when you continue to say, turn on your mic. Elaine, you are a gem. Well, I'm less annoyed. The voice gets edgier with annoyance. Let's see. I've seen the transcript of the motion to enter on Twitter. Judge A said Amber has to put up the 10 million. I'm also a lawyer currently in Tennessee. Hi, found you through the Depp trial. Hello, Lana B. Okay. I mean, some of the reporting says 8.5, but we will see. I just want to see it happen, and I want to see the filings at this point. Doesn't this ruling set a really bad precedent that you can be responsible if someone else says it? I thought defamation was also hard to prove. Defamation is hard to prove. It's not a ruling, it's a jury finding, and it doesn't really set a precedent. Excuse me. And I said that with Amber Heard's too. It's so funny because the pro Heard crew is very much like, this sets a terrible precedent for social media. This sets a terrible precedent, which I don't agree with. It's this case, this finding, and there aren't any rulings that are particularly novel that are going to cause a problem. But that's my opinion. But no one is concerned that Johnny Depp was found liable for defamation for shit he didn't say. They're very caught up on Amber Heard didn't even say his name in the article. Johnny Depp didn't even speak the words. So if you're mad that Amber Heard's been found liable for defamation for not even saying his name, are we mad that Johnny Depp was found liable for defamation for shit he didn't even say? But yes, you can, agents can act in your stead. I think it is a harder case to prove, but the jury found it proved. Check the messages from Lawn Lumber. Also, the reason your room feels hot is probably because the house, it houses the hottest lawyer prior to Camille Vasquez. Definitely not a hot lawyer. I just think the AC wasn't on. Lawn Lumber has sent all the super chats tonight and must be drinking because he's letting. Oh, wait. Joe left your house, so you could also just be doing things. I was going to say, hang out with Joe. Question, do you think LVP will put her 2 cents about all that's going on with Erica Jane if she comes back on Real Housewives of Beverly Hills? I have not seen rumblings that LVP is coming back. If there are rumblings, that would be interesting. I mean, LVP doesn't shy away from stuff. I'm sure she's watched it go down. How do you not? Can you please wish my sister Zena good luck with her bar exam? Much love from New Jersey. Zena, good luck with the bar exam. Stay hydrated. Smash it. Don't forget to take bathroom breaks. They're needed. Can criminal and civil cases run concurrently? It's difficult. For instance, with Murdaugh, there are so many things happening. Can the result of a civil case impact a criminal case or vice versa? Oh, T.S. Lizard Wizard. Here's the thing. It so depends on the circumstances. Sometimes one can get put on hold for the result of the other, depending on how interconnected they are. So far in the Murdaugh cases, there's nothing in the civil cases that should hold up the criminal, and there doesn't seem to be anything in the criminal that should hold up the civil. So I don't see a problem with them running parallel, but sometimes some things will wait. So if there is a civil case ongoing and then the criminal case resolves and there's guilty verdicts and then there's a question of restitution, that might wait until the civil case resolves. But when we're determining liability and guilt, they generally can operate at the same time. When we're talking about trials, we can have witness issues, so they can't run the trials at the same time, but the cases are still going to go along at the same time, if that makes sense. Brian J. from Lakeland Title, what came first, your podcast or your YouTube channel? The podcast or the YouTube channel came first, but the podcast was more consistent when it started, and then the YouTube channel switched direction and then grew in the same direction as the podcast. So yeah, we need another Wood Daddy Stack night. Well, we will ask all of the daddies to come back on another night. Just bumped SB, same name, but probably underwhelming. No, not underwhelming, Danny. It is hard. It is hard. It is hard. Because the thing is, on Insta, I get you get all the room for the requests, and the requests aren't ordered in any way, and there's hundreds of them. So hold on, let me pull it up on my phone and see if I can find it that way real quick. Let's see. Oh, this is funny. On vacation right now, big candy store in the hotel. A bit confused when I moved her out of the way to take a picture of the jelly beans. We now have a meme of the jelly beans. And the meme of the jelly beans, Danny, if you post it and tag me in it, I'll share it. It says, fuckery, Jelly Belly butter popcorn, floor to ceiling. Juicy Pear isn't even in the mix, much less its own slot. Justice for Juicy Pear. Juicy Pear does not have its own slot of jelly beans, but buttered popcorn does. That is complete fuckery. Juicy Pear needs its own slot. I agree with you, Danny. Justice for Juicy Pear. I agree. Question. Have you only had one drink? You've earned a second. Well, the ice melted, so I have second drink. So I do have second drink because the ice melted. Hello from Northwest Montana. We have a beautiful vacation rental across the river from Glacier National Park. That sounds delightful. I would love to get away, but when I get away, fuckery pops off. And then I'm not really away. Question, will the transcripts have the sidebars? I don't know. I want to see if your guesses were right. I want to see if my guesses were right too. I don't know how much of the sidebars we will get. Googly eyes, yes, I have. Quick hello. I've seen a quick bit of DUI breaking down the appeal cost and why. $500 is the Virginia cost for all appeal. Well, yes, we knew that. But the judge is allowed to order more or less. And we've also heard what the judges had to say. What do you think it will look like if Elaine writes the appellate motion? I can't imagine that she would. Most attorneys that do litigation do not do the appellate work. I can't imagine that she would. I hope that she doesn't. They're supposed to identify the bond they're posting in the notice itself, pull up the standard forms from the Virginia court website. Well, it seems like that's what Depp did. It's kind of annoying that her didn't then. Emily, I don't think she needs to post the suspension bond to appeal just to stop collections. That's what a Virginia litigator, not Rob, posted on Twitter earlier. And this is why the debate goes on, because we also have the judge saying that it needs to be posted at the hearing. And that's why the debate rages on. Do I know definitively? Nope. By the way, how much do you want to bet Johnny Depp's team had that notice of appeal drafted and we're just waiting to see if Amber Heard filed hers? I'm sure. Bet if Amber Heard never appealed, Johnny Depp would have moved on. I agree. And I think that this gives him another chance to continue to call her a liar and continue to talk about how he won. It just gives her way more of a chance to talk about this case. Leaf Lover Liz said body armor, coconut water, Sprite, and vodka. Sounds delicious. I made up a new cocktail for the law nerds. Love you, Emily. Thank you. Your favorite paralegal planet nerd from Murdoch County. Here to help let me know. You're my BFF paralegal for my state. Well, I will absolutely. There's a lot. Did Amber Heard's insurance also pay her counterclaim costs? Doubtful given the ongoing litigation. Thank you for the hose from New Zealand. Per Rob only needs 510 mil only if Depp isn't collecting anything. Well, I'm very interested to see what the court transcript says. I will go search it out because I know Elaine asked that she didn't have to post it. And I know that the court said she had to post the whole thing. So, they straight up put a statement saying, since she wants to continue, we are filing. I'm not surprised by that. Boogie says, I don't watch all your stuff, but I love your consistency. You're welcome. I'm sure nobody watches all my stuff. It's a lot. Sorry, I'm late. Pickle juice cures a hangover too. That is much more my speed, but I'm a very dirty martini girl. We don't mind it salty. Like the tears of my enemies. Salt, all the salt. How are you still alive? I don't know. I wanted to make sure I got to questions and I got carried away. I put too much on the docket tonight and ran away with lawsuits. But I also missed Tuesday and I'm going to miss next Tuesday because I'm going to be on a plane. So I feel like we're trying to cram a week's worth of live streams into each stream. But next week, which I should say housekeeping, and then I'm going to get to just a few more questions and leave because we have to. But next week, I'm going to be traveling to the Britney Spears hearing. So I will it is my goal to stream that night and then stream on Friday. So not stream on Tuesday, but stream on Wednesday next week. I just don't know what time I'll be streaming. I will keep you posted to let you know what time I'll be streaming. And then when I'm in court, I will obviously not be tweeting or texting or anything like that. Can't do that. But after the court hearing, I will try to see if there is any comments after court from Rosengard or anyone else. I will have my cell phone out. I will be taking cell phone video. We will be doing the things. We will just see. We will just see. Whoa, you're way more live than Ricada. I don't know about that. It's just a long one, but I start earlier. He streams forever. Love watching you from New Zealand. Try to watch all your streams because the entertainment is fire. Well, thank you. I sometimes amuse myself, so here we are. Question off topic. Who would you sue if defamed by one of the new AI commenters all over YouTube? Sheila, I'm gonna reserve that question. That is a pondering type of a question. That is not a quick question, because it's very interesting, because who is the personhood? Dark Emily, tears of my enemies. But I would guess the channel owner, because the channel owner is technically publishing it. So whoever owns the channel, but that becomes a jurisdictional issue because YouTube is an international platform. And I'm going to think about that more before I say anything else, because I don't want to make things easier for people. We're not here to be instructive. Emily, could you please say hi to my husband? We got him his first iPad for his 68th birthday so he can watch and rewatch you at his pace. Cleo's husband, happy birthday, and enjoy your new iPad. iPads are fire. They're so much fun. Emily, could the SC indictments break up by county due to civil asset forfeiture? It could be due to civil asset forfeiture that they're broken up by county, but most of them are being handled by the state prosecutors. So I don't know why the state prosecutors wouldn't just lump them together at some point, but we'll see. Dewana Montoya, I might have to just call one of the state. Can somebody explain this to me? Why are we doing it this way? I don't know. Or ask one of the defense attorneys, hey, why are they doing this? I just have not tried to ask. Cut 10 inches off my hair, donated it to Wigs for Kids. That's amazing. That's amazing. Just watch Incredibly Average's video of Amber Heard's deposition, and I need you to react to her lawyer saying objection trickery. Stop it. Don't ask her it that way. It's confusing. Gideon's Bakehouse, half-pound cookies by Goths. Jen, that sounds amazing. I want goth cookies. Sounds great. Sounds great. Thank you, Book Dragon, for the super chat. The Real Nike? Today is my 28th birthday. Happy to be watching. Happy birthday. I'm sure the Lawnard celebrated with you. Crazy Cat Queen, happy belated 20th anniversary. Emily and Dr. B. We didn't even post on social. We just spent the day together. It was kind of great. Wow, from UK, I finally managed for live. Well, I've been live forever, so you're welcome. I really love your videos. Please cover Bungie's lawsuit against Lord Nazo. I covered the lawsuit before they determined it was him. So that's on the channel. So the first part of the Bungie, I need to get to the next part. Rebecca, not in the last few days. I have a bunch of stuff to share on social. I think I'm going to share tomorrow. I've got a bunch of stuff to share on social. Will Cookie Monster be called as an expert witness? Lily, if Cookie Monster is not called as an expert, I don't want this trial. Nicholas says, Crumble isn't that good. They're overpriced. I have a friend who was general manager for one of their stores in Colorado. They cut a ton of corners. I think a lot of people thought that. The split screen is great. You don't look small on the other side of the screen. Lisa, thank you. That's what I was hoping for. I think their headquarters is here in Arizona in Tempe. Don't quote me on that. I think that's where Dirty Dough is as well. Talking Trash and Truth said hashtag Dirty Cookie Stack. Utah is kind of famous for its billboards. Thank you, Mary. Let's see. I'm going to get to just a few more of these. I know I'm getting to some of the older ones and some of the newer ones. Speaking of Marine attitude, in the MO responses earlier today, I attached a link of the judge in the Nicolas Cage case, not graphic, judge not having any of counsel's BS. Thought you'd appreciate. I will absolutely appreciate. I attached the link of the judge in the Nicolas Cage case. That I will absolutely go check it out, RK. We love when judges are not having any of it. We love it. We love it. We love it. So Rebecca, yes, I have checked my PO box, but earlier in the week, and I will be sharing. I have shared some of the stuff I got on Instagram, and I will be sharing more soon because I have a bunch of stuff to share on social. Question: what do we need to do for you to give the controls for the colored lights? What do we need? Wait, am I reading that wrong? Question: what do we need to do for you to give the controls for the colored lights? Give them to who? Who are we giving the controls to against the tide? To y'all? We can talk about it. The appeal feels like she's chasing him again because she's not done fighting with him. I mean, they have the right to appeal. They do. But it's just not done. And when you lose that much money, I can understand wanting to appeal if the statements all stopped. But Depp's team's not going to stop the statements either. It just is continuing to perpetuate. Your Bing clips with Dr. B, seriously, one of my favorite things. Thank you. I love your commentary, especially on Fridays. It helps not feel so alone on the weekends. Janae, you are welcome. Love to all the law nerds that make these streams so special. It is. The community makes this special. Angelica, Emily, maybe we misunderstood by she wanted to move on with Johnny's money. I mean, maybe. You and Runkle were quoted on cheatsheet.com. Fantastic. That is great. Lawn Lumber, they don't identify. Oh, I think you're answering the chat. We will see. We will see all of those in the actual appeal. Question: is this why Benju filed that motion about Rottenborn's closing after the case? Yes, they tried to preserve it for appeal. I still think it's too late, but they were trying to preserve it for appeal. So when lawyers say, oh, they're preserving it for appeal, that is why. That is why. Will you be covering the I don't know how to pronounce disassociate DID. I think that's right. Lawsuits, not at this point. I haven't even pulled them up yet because we have been so busy. H3 lawsuits giving Mike. Anytime I can't find something. Yep. Mike. Just sue Mike. If you can't do anything else, just sue Mike. That's what it is. Amber alert incoming. My kid's personal Uber. I feel that name so much. I feel that name so much. CDB question. Wait, I thought the bond was only to defer the collection and not a requirement of the appeal. And that's the confusion because the judge has said that she needs to pay it. So we will see. I still think there's confusion. Will they televise the appeal? No. Unless there's oral argument. I shouldn't say no so quickly. It depends. If there's oral argument, some appellate courts will televise the oral arguments. Most of it will be done by filed documents. So it's not going to have witnesses and things. Everything's going to be done on the transcript. So with that, law nerds, it is time to say goodnight. We are almost at 4 hours. It is long. Emily has to be up early. It is good. It is good. It is good. Maybe just create a single vanity thumbnail for just the quick bits and use it for all of them. I think that it would be hard to find them, but I appreciate the suggestion. I do. So with that, law nerds, I appreciate you. Law and Lumber has said oral argument is audio live. Then great. We will get to hear the oral argument if they go to oral argument, which I'm sure these attorneys will ask for. Well, these parties will ask for. And the public will ask for. We demand it. We want to hear it. And I love getting to hear it. So with that, thank you, law nerds, for being here. I will be back live next week. Be sure to follow me on the socials for when I stream at random times. And hit the bell here and subscribe and do those things. At the Emily D. Baker on Twitter and on Instagram, I will always post when I'm going live there. I also post in our member spaces on Patreon when I am going live and in our text crew, which is for North America only. We are working on an international option. Do not worry. And with that, it is time to say goodnight. You don't have to go home, but you can't stay here. I am sure there is another live stream around the interwebs. So I'm going to say goodnight. Thank you for being here. Thank you for being a law nerd. Have a great weekend. Take care of yourselves. Take care of each other. And, don't forget to go check out Two Dots, today's show's sponsor. 4 hours later, for those of you that did not know we had a sponsor tonight, we did. It was Two Dots. The link is down below. Go check it out. It's a lot of fun, and I enjoy it. All right, bye. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.